isolated the night very
We're off Monday?
It's a holiday.
Then we're off.
You come?
No, that's okay. I'd like to extend that holiday to Tuesday and Wednesday. Can we vote on that, Judge?
Again.
Will the vote count? It's more important.
I know the votes get. Thank you.
I'm gonna make sure. Fair enough. Hardcore plan. Yeah.
Can't reverse this.
Okay. That's
Don't jinx it. All right, let's go on the record, please. The state of Florida versus Denman, the president, defendant, his counsel, and the assistant state attorney, the jury's in the jury room. You want to discuss, counsel?
Yes, given that I think there's a bunch of stuff we probably need to discuss.
Can we first approach very briefly?
Sure.
anything?
No. No.
Check on the jury circulator.
Other issues that I wanted to address?
There are.
Sir?
I'm just bringing the jury. So tell me what your other issue is.
Ready, sir.
No, tell me what the issue.
The issue is we got presented this morning with a host of chat downloads that were reportedly downloaded from the chat account, whom the state reports to be Mr. Dumont, and the chat account. Before she introduces any statements, I think she needs to establish the relevance. This is just a download of a series of conversations. And putting them in en masse is a problem. Putting them in individually would require her to establish the relevance of the particular statement she seeks to introduce before introducing it. Our initial review of the contents that she wants to introduce shows relevancy problems, shows authentication problems, and shows prejudice and hearsay problems. So that's what we wanted to address before. We have a copy of what we're presented with here, and maybe we could present it to the court so you can take it.
I haven't seen it take a look at it. When do you anticipate presenting it?
Shortly after the first witness, but it's a business record on that. This is, and just so it's clear, this was provided as the initial discovery exhibit that was presented to defense counsel at the initial first ever discovery filing, and that was, it was on the exact date on that, but I believe that was approximately March 2019.
So let me ask you this. I haven't seen how many exhibits are there? How many are there?
This one's not particularly voluminous. There's a handful of pages, and then there are some video clips and some images. With regards to the images, I brought that to defense counsel's attention because there is one image that is on the defendant's Snapchat account that references some of the more inflammatory song titles. So I was going to tell them I'd be happy to hide that file so that the jury would not be able to access that or see that.
Okay.
And so I can provide those to Your Honor in the printout.
Sure, hasn't it been marked for identification?
It has not yet.
While we have it marked for identification, and is it possible that you do this or introduce these after lunch so we have a chance to look at them?
No, Your Honor. That's not for time frame on that. Like as I indicated yesterday, due to one of the witnesses having COVID, you'd probably have to end early this afternoon, and I beg your indulgence on time and scheduling on that.
Sure. There's an objection. I need to review it and see what it says. So after, who's the next witness? Yeah.
Tara Kelso, the RJ lead. Yeah.
So we'll talk about it after. Just have it marked as an exhibit. And if you could, just give a copy to Travis that after it's been marked, and I'll see if I can take a look at it as we're going. All right.
Understood.
But you said there's videos as well?
Yes, Your Honor. So there are
You're
videos.
objecting to the videos?
On relevant grounds, and authentication.
When we take a break, I'll look, you just play it. We'll see what
They're relatively short on the videos.
all right? You're were indicating that these social media are all from the defendant's account or something like that. Where are they from?
These are from the defendant's Snapchat account, Your Honor. And so I'll have it marked as stage triple J for identification purposes. Presenting to Travis a copy of the business records, authentication and certification, a copy of the printout of the chat records that are in a table format. Everything is contained on USB. I'm also presenting a printout of all of the photos that were associated with the account, as well as a copy of with the photo that could be potentially an issue of the name of the songs taken out, and a copy of printout of the first part of the initial clip or the initial frame of every one of the videos on there.
And you intend to play all of these videos to the jury?
Yes, Your Honor, because the defense is contesting whose account that is and whose phone was using this, so that's the state's initial relevance argument.
Thank you. And it's all the same Snapchat account?
It is.
Thank you.
Your Honor, as an initial, just so that you know, a Snapchat account, I'm not sure how familiar you are with social media, but a Snapchat account does not identify a device because it can be accessed from your computer. So I don't think that would be relevant to demonstrate.
Thank you. Now let's bring the jury in. Jury entering. Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the presence of the defendant, his counsel, the assistant state attorneys, and the ladies and gentlemen, I hope you have a nice evening and ready to proceed. Madam State, you want to call your next witness, please?
Yes, Your Honor. The state calls Tara Helsel.
Good morning. How are you?
Good, how are you?
Raise your right hand if you want.
Please solemnly swear or affirm that testimony given in the case of the truth, and nothing but the truth.
I do.
You state your family name for the record.
Tara Helsel.
You spell your first and last name for the court reporter.
Tarah. Last name Helsel.
Thank you.
Please, have a seat. Microphone in front of you, moves up or down, doesn't go back. Great.
Yep.
Counsel, you're ready to proceed.
Thank you. Good morning. Good morning. Can you introduce yourself to the jury and tell them where you're currently employed?
Yes, my name is Tara Helsel, and I work at RJ Lee Group.
And in what capacity do you work at?
I am a forensic scientist and the manager of the forensics department.
How long have you been employed by RJ?
Since November of 2016.
Can you give the jury a background into your education?
Yes, I have a Bachelor of Science degree in forensic science from Waynesburg University.
And how about some of your training and certifications?
Sure. So I had to complete RJB Group's training program for gunshot residue analysis. And this was a several month-long process that involved reading and learning the standard operating procedures, reading relevant publications about gunshot residue. I had to complete the analysis of 250 case samples, of which my results were compared to that of a trained analyst. I had to receive training on the scanning electron microscope, which is the instrument that we use for our analysis. I also had to take a test about that instrument, a test about gunshot residue overall, and then following all of that, I also had to take a competency exam.
Okay. And can you tell us, you mentioned that you also supervise?
Yes, I'm the manager of the department as well.
How many individuals do you supervise?
Right now, just one.
And so you're responsible for their overseeing their work as well?
Yes, absolutely.
And how many times have you ever testified in court regarding the area of GSR?
84 previous times.
And in the state of Florida?
Yes, I believe 13 of those were in Florida.
And other states as well?
Yes, I've testified in 20 different states, as well as Puerto Rico, Bermuda, and Turks and Caicos.
Has your entire professional career in the area of GSR been with RJB?
Yes, it has been.
Okay. Can you explain to the jury what is gunshot residue, commonly referred to as GSR?
Yes, so gunshot residue in the broadest sense of the term is referring to all of the particles that result from the discharging of a firearm. However, when I am talking about gunshot residue, I am referring specifically to the particles that come from the primer, which is one of the parts of the cartridge.
Okay. And what is the primer? And you can give us kind of a summary because you did hear from an expert yesterday regarding that.
Sure. So when you're thinking about a cartridge, it has the projectile or the bullet in it. It has gunpowder. And then at the bottom of the cartridge is something called the primer cap. And inside of there is a mixture called the primer. And that contains a couple of different compounds that together contain the metals of lead, barium, and antimony.
So lead, barium, and antimony.
Yes.
Okay, we'll remember those three. So how is it that gunshot residue is produced and deposited in the manner in which we then analyze?
So whenever a firearm is discharged and the trigger is pulled, this causes something inside of the firearm called the firing pin to strike the primer cap. So it'll hit the bottom of that cartridge and this will start a reaction. So this will cause the primer to burn, and the burning of the primer causes the gunpowder to burn. So as the gunpowder burns, there is a buildup of high heat and as a result, high pressure inside of the firearm. And that buildup of pressure is what ultimately will expel the bullet from the firearm. But because of that buildup of heat, those different elements I mentioned, such as the lead, barium, and antimony, are also going to heat up and become a gas. And this gas will exit the firearm through any available openings in the form of a vaporous cloud called a plume. So you have this gas exit the firearm, and it's now much fuller outside of the firearm than it was inside of the firearm. So those different metals will cool down and combine together and form particles. And those particles will land on the area surrounding the discharge, and those are the particles that I am looking for in my analysis.
And in general, how far is that gas traveling?
It depends on the environmental conditions. Things like weather and airflow can play a role, but in static conditions, typically about 4 to 6 feet.
Okay, and you mentioned the particles. What are the particles that are being produced by the discharge that you're looking for?
So there are 3 different types of primer-related particles. So the first are called particles characteristic of gunshot residue. And these would be particles that have lead, barium, and antimony all together in one particle. So these are considered characteristic because there are very few other sources of these particles aside from the discharge of a firearm. And it is the presence of those that we need to have to be able to call a sample positive for gunshot residue. There are also what are called 2-component particles, which would be any particle that contains two of those three metals. So it could be lead and barium, or lead and antimony, or barium and antimony. And these two component particles also can come from the discharge of a firearm, but there are other sources of them. So when they're found by themselves, they're not as conclusive to the presence of gunshot residue because they could have come from something else. But if they're found in combination with particles characteristic of gunshot residue, they're more likely to be from the discharge of a firearm and are kind of acting as part of that GSR population. And there is a third type of particle, which is just a one component particle, which would be lead by itself, barium by itself, or antimony by itself. And these also come from the discharge of a firearm, but there are even more other sources of those particles to where they're not very conclusive to the presence of gunshot residue. So we, our GLE group, do not report on those. We are just reporting on the characteristic particles and the two component particles.
And that's because, for instance, lead can be found in paint.
Yes, absolutely.
So the presence of lead in and of itself isn't indicative of GSR.
Exactly.
And can you describe for us how you perform the analysis? And I know you brought up the microscope, which you briefly mentioned yesterday. Can you describe for us how that microscope works and your process?
Yes. So we use an instrument called the scanning electron microscope, which is also referred to as the SEM for short. So this is a very powerful microscope, and it is computer controlled. So instead of looking at your samples through an eyepiece, like you would with a traditional microscope, you're actually looking at them on a computer screen. And this instrument has the ability to magnify by thousands of times. And it also allows you to see the chemical composition of what you are looking at. So because gunshot residue is extremely small and not visible to the naked eye and is made of very specific elements, that's why we use the SEM. And the way our analysis actually works with it is two parts. So the first part is an automated analysis. So I will take the samples and put them into the microscope, and I will set up parameters on the computer telling it, here are the samples I have, here's where they are located on my sample folder. From there, the computer will scan the surface of those samples, looking for potential gunshot residue related particles. If it comes across something that it thinks could be gunshot residue, it will stop and take a picture of that particle and also save the coordinates for where it is located on that sample. So it will finish going through and scanning all of the samples, and after that, I will do the second part of our analysis, which is the manual analysis. So I will go back to those particles that the instrument flagged, and I will examine them. So I will look at their shape, and I'll see if that's consistent with gunshot residue, which would be something that is smooth or round in shape as the result of a high heat reaction. In addition to that, I will look at the chemical composition of those particles and make the determination for what type of particle it is that I am looking at.
And the automated process is performed by the SEM, right, with them, for short.
Yes.
And what is it looking for? Those particles that we discussed earlier, or the compounds, the barium?
Yes. So basically, the way the SEM works is kind of based on brightness. So the more dense something is, the brighter it will appear. Because lead, barium, and antimony are heavy metals, gunshot residue-related particles will appear very bright. So it's scanning the samples based on brightness. And if it finds something above a certain brightness, that's when it will stop and collect a spectrum to determine what elements are in there. If there's lead, barium, or antimony, or any combination of those, that's when it will save where it's located and take a picture of that particle.
And would a demonstrative aid assist you in your testimony to the jury as far as what the SEM shows?
Yes.
Again, ladies and gentlemen, the witness is going to be using a visual or demonstrative aid to assist in explaining or illustrating her testimony. Just remember that the testimony of the witness is the evidence. However, this demonstrative aid is not to be considered by you as evidence in the case unless later received as evidence. and you should not use it as a substitute for evidence. Only items that are actually in evidence will go back with you to the jury during your deliberations. You may proceed, counsel.
Thank you. And without getting into the actual results, we're just going to orient the jury to the chart that I have here, beginning with the top left.
Yes, so the top left is an image kind of showing where the particle is located on the sample, and that is taken at 400 times magnification.
And the top right.
That is now a closer up image of that particle taken at 3200 times magnification, where you can see clearly that it is bright, it is round in shape, and you kind of are able to visualize really the morphology of that particle.
And bottom left.
So that is what is called the EDS spectrum. Basically, it's just showing you what elements are present in that particle. So PB is lead, BA is barium, and SB is antimony. So you see peaks for all of those present in that particle. Therefore, it is a particle that contains lead, barium, and antimony, which makes it characteristic of gunshot residue.
And are the peaks that we see consistent with the amount of that compound within the sample?
Yes, overall, the height of the peaks relate to how much of that element is in the particle.
And finally, the bottom right.
So that is the image that the instrument takes during the automated analysis.
And did you receive a sample in this particular case for analysis?
Yes, I did.
Your Honor, approaching defense counsel will be introducing now the state's LLL for identification purposes. Your Honor, permission to approach the witness.
You may.
And if you said you have anything biological, there are gloves right there, and the top has been injured for ease of access. Tell me if you recognize it first, and if you need to open it, if you can just keep it outside the view of the jury.
I do recognize it.
And how is it that you recognize it?
This is one of the items that I received in this particular case.
And it was one sample, and what did that sample contain?
It contained a collection stub labeled as coming from the inside of the Jeep.
Okay. And is that in the same, substantially the same condition as the last time you saw it?
Yes.
Your Honor, at this time, the state review determined is pre-marked states LLL as the next number to exhibit.
No objection.
Thank you. It'll be admitted. What's the next number?
60.
60 in evidence. Thank you.
Looking for 57. I'm showing you what's been entered into evidence in states 57. Do you recognize that?
I do, yes.
And what is that?
This is a gunshot residue kit that we received in this case.
Okay. And did you analyze states 57?
Yes, I did.
And did you ultimately analyze state 60?
Yes, I did.
So, grab your scissors. Go ahead and open these states 57. And I'm going to ask permission from the judge for you to step down.
You may.
If you want to open it, grab some gloves, and we'll.
Okay.
Just speaking, published state 57.
And the contents. So you received one sample, but there are two tubes.
Yes.
What are they representative of?
These were samples that we had received that are labeled as coming from the right hand and the left hand.
And who's the individual?
Cortland Henry.
And we can put those back in. And if you can publish states 60. And we have one tube, and what is that representative of?
It is labeled as coming from inside of a G.
If you believe it, it will adjust. Thank you. You can put it back in and take your seat. Okay, we're going to start with case 57. Did you ultimately have a chance to analyze and go through this STEM process, which was the automated process and your individual process, in order to come up with an opinion as to the presence of GSR?
Yes.
And what was that? And if you can specify both the left and then the right.
So the right hand of Cortland Henry contained 0 particles characteristic of gunshot residue and two component particles. And the left hand contained 1 particle characteristic of gunshot residue and 1 2-component particle.
Okay. And can you explain to us what that means?
Basically, overall, there was gunshot residue present on the hands.
Okay. And what affects the presence or absence of GSR on a person's hand or any object?
Sure. So if there is gunshot residue on someone's hands, that means that the individual got it on themselves by either discharging a firearm, being in the proximity of a firearm when it was discharged, or by coming into contact with a surface or object with gunshot residue on it.
Okay. And if we may go back to the demonstrative aid, what was this demonstrative aid? Was this representative of your results with Cortland Henry?
Yes, that was the particle characteristic of gunshot residue that was on the left hand.
And the components, which you explained before, there are three kinds or 3 compounds that you were looking for, and which compounds were present in Cortland Henry's left hand.
Lead, barium, and antimony were present.
So all 3 components.
Yes.
Okay, and let's move on to state 60, which was the sample from the G. What were your results? And again, did you also go through the STEM automated process and then your individual characteristic process?
I did, yes. So there were 0 particles characteristic of gunshot residue, but at least 9 2-component particles.
Okay. And what does that mean?
So, like I mentioned, 2-component particles can come from gunshot residue, but they also have other sources. So, because of that, these results are basically inconclusive. They could be gunshot residue, but they also could be from something else, and I can't say which it is.
Okay. In your analysis and reviewing the sample, did you find anything inconsistent with gunshot residue, if I'm phrasing that correctly?
Correct, and I did not. So overall, with two component particles, or any of the particles we look at, if the particles are from another source, there are other elements or amounts of elements that would be unusual to find in gunshot residue. So, for example, one common source of two component particles is brake pads. Brake pads typically contain high amounts of the element iron. So if I'm doing my analysis and I come across particles with high amounts of iron, I eliminate them and I do not report them because there's something about them that would suggest they're from something else. So while I still cannot call these particles gunshot residue, there was nothing about those particles that were unusual.
And I want to ask you about presumptive tests. Are you familiar with them now?
I am.
Are you familiar with the friend or foe presumptive GSR kit?
I am.
What is that kit testing?
That kit is like you said, a presumptive test that is looking for the presence of nitrates, so nitrogen-containing compounds.
Okay. So, for instance, these GSR kits are made to essentially alert to the presence of a certain compound.
Yes.
And the friend or foe kit specifically alerts to the compound of nitrogen particles.
Yes.
So the presence or absence of nitrogen particles.
Correct.
And are presumptive tests relied on exclusively?
No, they are just a screening tool. Like I mentioned, they're looking for nitrates, and there are many things that can contain nitrates. So they are not conclusive to the presence of gunshot residue or gunpowder. They are really just to be used as a screening tool.
Your Honor, movement to confirm?
Yes.
Nothing further.
Councilor Zink Ross,
Yes,
you're ready to proceed.
thank you. Good morning.
Good morning.
I don't think we've had an opportunity to meet.
No.
You got the sample from Miramar Police Department,
Yes.
specifically Detective Moretti directed it to you.
Yes.
And when we talk about GSR, or gunshot residue, you're aware that GSR can be found on clothes, right?
Yes, that's possible.
Did Detective Moretti send you any clothes of Cortland Henry?
He did not.
He didn't send you any of his clothes?
No.
Did you know that the clothes of Cortland Henry were collected by the Miramar Police Department?
Objection, call for speculation outside the scope of the trial.
Well, I know that calls for speculation. She knows she can answer the question. Overruled.
Were you aware that the Miramar Police Department collected Cortland Henry's clothes?
No, I was not aware of that.
But if in your examination, had you received clothes, you could test those clothes for GSR, correct?
Yes, we can
And you-
certainly test clothing.
And you've done that many times, correct?
Yes, absolutely.
Also, if someone is in a hospital, in a bed in a hospital, do you know if that person has washed their hands?
I don't.
Okay. And by washing your hands, you can get rid of GSR, correct?
Yes, hand washing can remove most, if not all, of the particles on someone's hands.
Do you know if Cortland Henry washed his hands or changed his clothes?
I don't know that.
Can I have one moment?
Yes.
Thank you very much.
Thank you.
Any redirect?
Yes, Your Honor.
Is hand washing the only thing, contrary to popular belief, that removes gunshot residue?
No, gunshot residue is easily removed in general. So with respect to the hands, any type of activity, touching or use of the hands can remove particles pretty easily. With clothing, any activity. So if the garment is touching things, if it's laundered.
If it's removed?
Yes, any activity can cause particles to be destructed or removed.
And you're an independent lab, correct?
Yes, we are.
You're not associated with Miramar Police Department.
Correct, we are not.
You're not associated with the Broward Sheriff's Office.
We are not.
So you can only test what you're submitted, correct?
Correct.
Nothing further.
One question. If I may. You were hired by the Miramar Police Department to perform this test, correct?
Yes, they're the ones that submitted the samples.
Thank you.
Anything else?
No, Your Honor, nothing further.
Is this witness excused?
Yes, Your Honor.
Thank you very much, ma'am. Can you step down your seat? Thank you. Can I see step up, please? Ladies and gentlemen, I need a few minutes with the lawyer. Please do not discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in present. It's clear for no research. Thank you. Just leave no headline carry. I let the record reflect the juror stepped down, counsel remained, the defendant, the assistant attorneys. So I have, and this has been marked as states JJJ triple J, and it's Snapchat account. And so what does this purport to be?
That is the business record production from Snap Incorporated, which is the business that runs the social media app of Snapchat. The records are the records of Mr. Defendant Jamell Simmons. They are conversations and statements that he makes, some of which reference this homicide and Portland Henry. There is a specific comment from Mr. Defendant to an individual that's identified by a Snapchat name, and it's on there, DHAT is what it starts with, in which he says that Portland Henry did something very important for him. I'm paraphrasing from the language on that. In terms of establishing that those records belong to the defendant, the state has to prove that beyond a reasonable doubt to the jurors. So that is why it's necessary to show that all of the photos and videos in that particular item are of Jamell Simmons. In addition, the person that he is speaking to, the one that starts with DHAT, that individual, there are images of her that are transferred back and forth. So that is identified as Melania Hamilton. That is the defendant's girlfriend at the time. She's also in some of the videos. And then there are videos that the defendant sends to her that in which he indicates you shouldn't be speaking on me, basically discouraging her from speaking with law enforcement.
So regarding these videos, how long are they? How many? I mean, you sent me a
Yes, that's
3
the,
pages listed. I don't know how long these tapes would take a look at.
they're less than 30 seconds each approximately.
So let's put them in.
The drive that is right there.
I'm going to angle that.
Well, yeah, that's fine. Just has to go back. But why don't you stay over there? Is the RP still over there? Or you- They good?
I think that might be good.
You can reposition yourself.
Yeah. Thank you.
Feel free to do that throughout.
Thank you,
If
sir.
there's something showing up on the screen and you think you want a better view of it, you're always welcome.
This is the business records certification as included on the file from Snapchat.
Yeah, I saw those. I'm not talking about that. I'm talking about the actual videos.
So do you want to see the images larger as well, Your Honor?
Yeah, I'd like to know what you're going to show to the jury. They're objecting to it, saying it's not relevant. You know, I don't believe there's an objection that's not authentic, that it's, not his account from Snapchat. I understand if that's the case, but my understanding is they're saying it's not relevant.
This is the one that I indicated would potentially have the items the defense didn't want in, such as the names of the songs of the defendant.
We don't have to concern ourselves about that. State agreed to get that out. So,
Image of the defendant. An image of the defendant and Mariah Hamilton. Image of the defendant.
You're saying that this is the defendant and Mariah Hamilton, and I haven't heard anybody identify her yet. Is that,
Correct, that's why the next witness would do that.
Oh, okay, so the witness is going to do that.
Yes, Your Honor. There she is again. That is Ms. Hamilton. This is the Snapchat logo of the defendant. Moving on to the videos. This video here is before the homicide. It includes the defendant and one of the victims, Christopher Thomas. There is volume to it. I don't know if the TV is turned down.
Gary, can you check on that? That's good. No, that's up. That's 63 or 62. There's a button.
Try PLC.
That was the LC. So.
Oh.
Yeah, I think. Sharon, I'll switch over to a different computer. Very nice.
This bitch look like he got 5 kids at the student pickup right now, waiting.
Your Honor, for the interest of time, should the state be proffering the relevance of each video as we go?
Oh, thank you. I'd just like to see it and see what, my understanding. Well, go ahead.
Okay.
Right. I'm interested. Maybe the most important thing right there. You know you do that. You be someone pick up on me. It'll be a deal. But I make sure, I make sure, what's saying when you get out, do it, what's saying when you get off y'all ass, man. Get off y'all ass, man. He didn't do that. I've been out here about to saying you did.
Those all the videos, Councilman?
Yes, Your Honor.
All right, so, Councilman, why don't you tell me your complete objection so I fully understand what you're objecting to on the videos as well as the remaining portion of this Snapchat under, I think it's triple A.
Your Honor, our first objection would be relevance. I think Florida statute 9401 defines relevance as evidence tending to prove or disprove a material fact. There was not a single video that you witnessed there that implicates in any way any fact and issue in this case. I want the court to be aware of what a Snapchat account is versus a video off of a phone. They're two different things. You can access that Snapchat account from your computer that's right before you. So a Snapchat account or any social media account is not particular to a device. This is contents from an account that exists in the cloud or on the platform of Snapchat. and is not peculiar to a particular device. So it doesn't identify a device. It identifies a social media account. The notion that anything a defendant says can and will be used against him is an issue of hearsay. It's not a relevancy issue. None of those videos I haven't heard, and I think that probably we're putting cart before the horse by making me object to the relevance before she advances her theory of relevance. But the fact is, unless I'm missing something, there is nothing there that concerns the events of October the 26th, 2018 in any. As far as the messages are concerned, it's similar.
Now we're talking about what's in writing, correct?
What's in writing is essentially a dump from that account, a selective dump, I think from August the 3rd through some date in November. If the state is indicating that there are messages there that relate to the offense, then the state should isolate those messages and make its argument as to what the relevance of those statements are. But to suggest that you can just dump all statements that somebody makes since birth until the time of their trial, and because it's non-hearsay because it's a statement of the defendant. And by the way, these are exchanges, so a relevancy objection, a hearsay objection relates to the statements of the defendant, not the ones that are made back to him in any kind of conversational exchange. Those statements themselves are hearsay because they aren't statements of the defendant. And I'm making this argument assuming, because I'm dealing with relevance here, assuming that those statements are indeed statements of the defendant, which I'm not conceding. They have to have some relevance to this trial and facts and issue at this trial. There are some statements that I observed that seem to be some maybe terse or conversations between him and any person that might cast him in a poor light because of the manner in which he communicates. How is that relevant to this case? So relevance is number one. A statement has to be relevant. So each statement the state would have to establish the relevance of each statement in isolation prior to it being admitted into evidence. Saying these are all from his phone and therefore they're all his statements and this is a business record exception and therefore they get in doesn't cut it. As far as authenticity is concerned, that's our relevance objection. Relevance must be established. I'll cite the court authenticity issues or authentication issues concern Rule Florida Statute 90.901. And I'll cite the court to some case law that doesn't necessarily deal with social media, it deals with text messages and emails. Simonet. I can't remember if it's Simmons v. State or State versus Simonet, but it's 100 Southern 3rd 180, which stands for concerns text on a cell phone. And it indicates, these are some notes that I took down because I didn't realize she was going to be trying to bring this in today. We had asked for some indication as to the witnesses, and I think this is the only day we didn't get any indication And so there's an element of ambush. But nonetheless, in the Seminole case, it stands for some legal principles that were articulated in that holding that I took note of. One, in that case, there was a concern regarding the admission of screenshots of text messages, communications. And the court said it was okay because there was a witness that testified that she was sitting next to the defendant in a car when the texts were made. And the detective recovered a cell phone from the defendant, and the witness identified the text messages between her and the defendant. In other words, there was a party to the communication who was able to authenticate the communication and who the participants are. Another case is Roy, which is 279 Southern 3rd 238.
279 what?
Southern 3rd 238, which concerns emails and texts. And these were emails that were admitted through the investigator that was posing as a 14-year-old in what appears to be a case that concerns some sort of a pedophile sting. And the investigator involved in the exchange, the investigator was involved in the exchange in the emails of the text. One of the quotes that I took from that case says, most common way to identify social media, which would be this, and things akin to social media, is to let the author testify that they're the ones who generated or created it. So there's somebody that is involved in the exchange of the communication that can attest to the fact that they created it or were involved in it and identify the parties that were involved in the exchange. When a participant is used to authenticate electronic exchange, the focus is on the witness's ability to identify the person against whom the communication is offered. In criminal cases, the person communicating with the target of the investigation must be able to identify the target through some personal knowledge or experience. So this establishes that there has to be somebody who participates in the communication, who authenticates the participants in the exchange, and must be able to identify the participants in the exchange. In the Roy case, the sergeant, who was posing as a 14-year-old, acknowledged that he had no idea who was on the other side of the emails and text. Here we have nobody at all, let alone somebody whose knowledge is insufficient.
This is just a PC affirm case. These opinions were, right? Am I reading this right? This is a PC affirm. That's in the concurring opinions or?
Roy versus Gay. I can print it out.
I'm reading it right now.
I'm not sure what the court is.
It's a PCA affirm.
Meaning the language that I'm reading doesn't exist?
Not that it exists, I'm sure it's there. I didn't read the whole concurrence. It's
Okay,
there, but it's a PCA affirm.
Well, maybe I cited it incorrectly. I have.
You cited it right. 279 Southern 3rd 238. All right, go ahead.
Okay, this is language I took from the cases themselves.
I don't doubt it.
Okay.
Seems like it's all here.
Okay. I'm not sure the significance of a PCA affirm meaning.
That's not the opinion of the court. It's the opinion of one judge. That's what his concurrence was. His or her opinion, and there's another judge has a different concurring opinion. There's no specific majority opinion. I don't see it. The other concurring opinion says he reversed, but it's a PCA affirm.
I'm not quite sure of the significance of that, but I'm sure the court has a message it's communicating. No evidence that the texts were recovered from a phone, A, belonging to, in the possession of, the appellant pursuant to a search warrant, is another quote. Further, in that case, the sergeant could not identify appellant as a person on the side of the emails or on the other side of the emails or text. Lamb versus State, 246 Southern 2nd 400, 4th DCA case in 2018. A quote that I took from that says, a case involving authentication of a Facebook video or videos here, is also instructive. In that case, the fourth district recognized a distinction between authentication of a video recording and an audio recording. An audio recording would be more akin to a communication that you can't tell the identity of the communicators visually. The fourth district acknowledged its prior holding that authentication of an audio recording, quote, should be made by the technician who operated the recording device or a person with knowledge of the conversation that was recorded. Quoting Santana versus State 191, Southern 3rd, 946, which is another fourth district case. So as far as authentication is concerned, Your Honor, and the PCA affirmed component, notwithstanding the articulation that is being made repeatedly by district courts of Florida, of this state, and by the fourth district, are that when you are introducing text messages, communications that are in print, audio, somebody has to identify the participants. You can't just put them in and say, this is the guy who said it. You have to lay a predicate of authentication, which the state is not attempting to do. So as far as relevance is concerned, they have to establish relevance of each statement. They can't just say, here are all the communications he ever made, and notwithstanding who he's making them with, whose statements are themselves hearsay, because his statements are statements of the defendant and therefore not hearsay, non-hearsay by definition, they come in. They have to establish the relevance. So we object. One second. So the communications are not particular to a phone, so it doesn't meet that hurdle. They are particular to a social media platform. A social media platform that they have to establish belongs to the defendant, and I don't think they have said how they purport to do that. Even if they do that, the statements of anybody else in those exchanges is hearsay. Statements of the defendant are irrelevant, and the photographs and videos are also irrelevant and prejudicial pursuant to 90.443.
Thank you. And I misspoke. It was one opinion. It's a PC affirmed on Benjamin D. State, or Benjamin D. Roy v. State, that you cited 279 Southern 3rd 238. It's a PC affirmed. There is a concurrence, and he would concur in part and would reverse in part. I misspoke. All right. So yes, counsel, you want to be heard?
Yes, Your Honor. With regards to, and defense counsel already has the Lanham case, so I'm familiar with printed copy, Your Honor. Specifically, authentication for the purpose of admission is a relatively low threshold that only requires a prima facie showing that the proper evidence is authentic. I'm reading on the 9th page with notes 5 and 6. Lanham case goes on to state that authentication for the purpose of admission is the ultimate determination of authenticity of the evidence. Is a question for the fact finder. Evidence may be authenticated by appearance, content, substance, internal pattern, or other distinctive characteristics taken in conjunction with the circumstances. In addition, the evidence may be authenticated either by using extrinsic evidence or by showing that it meets the requirements for self-authentication. With regards to the evidence before Your Honor, the defense is not agreeing that it is his account. So then the burden is on the state to prove that it is his account. As such, the evidence itself shows that it is authentic, as it is the defendant in every single one of those videos. In terms of the contents of the defendant's statements, they are relevant. They go to the issue and fact of whether or not he committed these two homicides. The contents of the questions are important for giving context. An answer without any context doesn't give the fact finder, the jury, any way to meaningfully evaluate the statements. So based on the standard, which is low for authentication, the state has done that by the business record certification and the fact that the email address and everything else will be linked up in other witnesses as well, showing that that was the defendant's particular iCloud account that is the username. It's also important to note, Your Honor, that while the individuals, it doesn't tie it to a specific device, it ties it to a specific individual because it's a unique logon and username and password, just like an email account, that it was used by this defendant.
Thank you. Anything else, Counsel?
Yes, Your Honor. There are statements there that, in the conversations that started on October 3rd. October 3rd, this incident occurred on the 26th. The state is making a blanket assertion that these statements go to demonstrate his complicity in these homicides. Each statement has to be identified and the argument has to be made as to each such statement by itself so the court can have a way of evaluating the purported relevance. They can't just say they're relevant to the homicide. That is insufficient. And if they do not identify each particular statement and the relevance of each particular statement, then dumping them all in on some blanket assertion that they're relevant would be error, and it would invite error, and it would prejudice Mr. Demons irreparably. So, context for what? He's having an argument, a discussion with somebody on October 3rd. If they're saying that that constitutes some plan that establishes premeditation, then let them advance that argument. They have not referenced a single one of those conversations with specificity and advanced some argument that ties it to a fact and issue in this case. So I would say that on the relevance alone, the state fails to make a showing that would allow the court to even properly analyze the question in issue.
Thank you. I'm going to defer ruling out, take a look at your cases that you just sent. We're going to take a short recess. Mr. Demons, any recommend break? Yes. Yes? We're ready for recess. We'll be in recess. Thank you. My thought is this, I understand the defense objection not be admitted, allowing the evidence to come in. However, there's a couple caveats. Number one is, one of the videos I saw has a gun in it. That's all.
There's access to the murder of firearm 6 days before the homicide.
Right. I don't see how that is relevant to anything, and I think it's more prejudicial and probative, and it shouldn't be. All right? So I'm not allowing that weapon. It's not like you had something 15 minutes or a half hour before the incident in question. I'm not letting somebody with a gun, days before. That's number one. Number two, I know there's been no argument that 403 analysis, but I don't see how any of the pictures and the videos with all the flashing and cash and all that really has anything to do with anything. I want all those out. I'm not admitting those. All right?
So the videos of him in the bathroom with the stack of cash.
Anything where he's flashing all the cash, I don't see how any of those things are relevant. They're more prejudicial and probative. The gun is more prejudicial and probative. I'm not letting it.
Okay, so what I'll do, with your Honor's permission, is I will pull them up here and verify them. Then I would be changing the business records on that. But that's working with your article. So that be these 3 videos in the bathroom. But with regards to this particular video, the second video doesn't have the defendant's picture in it, so just so it's clear. And so, Your Honor, what I would suggest is that I can modify that video to take out the part where the gun is there, and then, so it would just go from there, and then excise the portion of the gun, and we could that showing who is speaking, and showing who is then showing the driver's license.
It's fine. The gun should be out, not
Your Honor,
staged before.
could she at least articulate the relevance of anything? I mean, I
I
understand.
heard your argument, I understand it, and I've overruled it.
It is overruled.
Overruled. The only thing I'm doing is a 403 analysis thing that you can't, I don't see the relevance, I don't see the probative value of the gun and the cash being allocated by overruled.
Defense counsel is also asking to take out the photo of the song and their titles or whichever else.
Right, I agree, take it out. Murder on my mind.
Sarah, I just need about 5 minutes to fix that video.
All right, we'll be in recess, you work on it. Jesse, you want to say something?
Yes, Your Honor. So has the court articulated its ruling concerning the visual images, the videos, the pictures, or has the court already also decided that all the communications come in without the state asserting a relevancy objection as to each state, or a relevancy as each state?
Counsel, the videos, my understanding, the videos as well as the written conversations are you articulated and objected, saying they're not relevant and they can't be authenticated and things like that, and the objection is they can't be authenticated, you don't, because how Snapchat works, anybody could have done it. And counsel's suggesting to me that she needs to put it in to show that it's his, because he's the one that's picture on those accounts, it's authenticating. I know I'm the determination of what's authentic, whether it's authentic or not, I'll make that decision. But it appears to me it's going to be argued that it's not his account, or he's not the one that's putting this information on there. That's the tenor of what you're suggesting. So it just seems to me that goes to show who's on the account and whose account it is.
No, I understand that, Your Honor, and please do not understand me to be arguing a decision that the court has made. I'm trying to understand that saying that we're going to put all this in to prove, we're going to put in all these conversations to prove that it's his Snapchat account. Why are they trying to prove that it's his Snapchat account if not to get the very statements in? So if the statements themselves are saying, well, we're going to put in these statements to prove it's his Snapchat account, should they at least articulate why are you trying to prove that it's his Snapchat account?
There's a statement in there which there's the state believes is the admission.
Okay, well, if that is the case, then that statement should come in. And if those statements are isolated, then the defense would be in a position to determine whether or not they're going to take the position that it is not his Snapchat account and do a 403 analysis of our own. So if they're saying there are 3 statements in there that constitute admissions, fine. If they might want to put those in, and we might say, okay, we're not going to contest that it's his account, so you don't have to put in all the other stuff that is prejudicial. But they have to at least articulate it and isolate it so that we can make an informed decision.
Thank you, counsel. You didn't bring up the fact that there's it's overly prejudicial. You had a straight relevance objection and authentication objection. I've overruled those objections. When I looked at the video, I said, nobody else, I said, I think that's too prejudicial, not probative of anything, the picture of him with the gun, and I want it out of there. I said the same thing regarding cash. You did tell me, and I didn't articulate it, that you were concerned about the video with the murder on my mind, and I agree with that. That should be out as well. All right? Okay. So that's the ruling. It's the relevance objections overruled. The authentication objection, I admit it, but I don't want the items that I previously discussed being shown to the jury.
Thank you.
Yes, I may have a moment to show defense counsel the clip as it's been.
Go ahead. We're on recess from that.
Yeah.
Show whatever you want to show.
The other one's already taken out. This is the other one to take out the gun.
Take on of these so-called videos on.
Yes, they are on the specific one.
I see that diagram. Yeah.
So, yes, it's here.
I have a moment to speak to the stand.
Yes.
Come on over.
You're in recess.
The purpose of this is Snapchat.
Can you at least identify what you think is a confession in there? Identifying why you would not identify, because then you might not be the objection to the rest.
But you probably still want to that.
Yeah, but then it would be admissible based on her. Yeah. I'm not concerned about the judge said take him out. Take him out. If you take him out, don't take him out. I don't mean to.
Anything else about the mission status? No.
No, I'm going to take the position that if you think there are confessions in there or statements that implicate him, identify them.
Conversation.
On November 9th, when we, what I'm saying identify what you want in, because you think it's all admissible to prove that is his account. If we're not contesting that it's his account, then you are taking, you're putting in a form of information. Identify what you want in so that we can make the equal decision. If you violate a judge's order, then it's your problem. I don't need to review it. I know you gave me a pass.
Yes.
Okay. I'm not trying to be difficult. I know that that's probably a little bit times.
Council's going to take you a few minutes?
The video is done.
So, they just, I was thinking of taking a piece.
And we just wanted to be clear that if we are,
Be on the record again?
yes, just so I can complete the record on this one point.
Let the record reflect the presence of the defendant, his counsel, the assistant state attorney, jurors, and jurors. Yes, sir?
The state is asserting that among the conversations in state's exhibit, what was it, mark for identification?
Okay.
Triple J, that there are certain conversations or certain exchanges which she believes relate to facts and issue, and that the rest of them she is using to authenticate or to establish that it is the account of Mr. Demings. I'm just putting on the record that the defense would be willing, if she does isolate those conversations, to consider not objecting or not making the claim that it's not his account, so that she can get in whatever she deems is relevant, and we can avoid the prejudice of the remaining contents that she intends to put in that is not relevant, and she only put in to establish that it's his account. I just wanted it to be clear that that is an offer that we have tendered to the state and we're articulating for the court. Thank you.
Thank you. What does the state?
Your Honor, the state is going forward that the state has to convince the jury beyond a reasonable doubt as to the authenticity and who those messages link to. And that was the way defense counsel indicated from the beginning that that is how the state needed to proceed. So at this point, the state would enter the evidence as it is currently closed.
Thank you, Judge. Please, is there, I mean, there's whole conversations with Ms. Mariah Hamilton that really, I mean, that goes to authenticate the whose the account it is, but I don't know that it does anything other than that. And can I see the exchange again, please? JJJ.
I left it right there, I'm sorry.
Mr. Eaglestein asked me to print another copy for him, so I'm trying to work on that.
I'm sorry. No, it's my fault, I accept responsibility. But of course, I get two points off my guidelines.
So let's get back on record. Again, let the record reflect the president, the defendant, counsel, and the assistant state attorney, jury, and jury room. I'm not fully understanding everything that you're saying. Mr. Howard, you're telling me that you're not objecting to the Snapchat conversations, not going to argue to the jury in some way, shape, or form, but it's not him if it's limited to what the state is suggesting, so the conversations between he and his girlfriend and things like that wouldn't come in. Is that what you're saying?
I am saying, Your Honor, that if we need to be able to make an informed decision. So I am saying that we need to know what he deems to be relevant, and then when we know that, then we can make a decision that, okay, well, we think that it makes more sense to not make the argument that it might not be his account.
Okay.
So that she can get our evidence in, but to get the rest in. Your Honor.
No problem. We'll just leave it the way it is.
Okay. There may be another issue, not as though you don't have enough on your plate here. We have reason to believe that the state intends to call Miss Felicia Holmes in this next session. And there is the law in this jurisdiction and in this state is that a witness shall not be called merely to be impeached. I don't know that that is the case or not, but I'm concerned with trying to unring a bell. The theory is essentially a statement that the state knows that they will not be able to elicit, and they seek to only impeach their own witness by a prior inconsistent statement, amounts to hearsay because it's being offered for the truth of the matter asserted. So when the state calls a witness that they know is about to, and these are instances when a witness says A and then recants and says B, and the state wants to get A in and knows that the witness's current position is B. To put the witness up there to say B and then impeach them with A is improper. I have here some cases, a few for the court, stand for that position. Dudley v. State, 545, Southern 2nd, 857, Florida Supreme Court, 1989. Felton v. State, 120, Southern 3rd, 126, Florida 4th DCA, 2013. Curtis v. State, 876, Southern 2nd, 13, Southern 2nd, 13. And that's first DCA, 2004, and there are many others. And may I hand up? I have highlighted copies of the cases.
You have them for a state as well?
I do indeed. If I may.
Take a look, whatever you got.
Thank you, sir. Now, I understand that this might be a little bit premature to the extent that I don't know for what purpose they seek to call Ms. Hamilton, but I don't want to be in a situation where we're trying to unring a bell when we are in a position to avoid that prejudice from occurring. So I'm alerting to the court to that possibility, and if that is in any way the state's intention, I would ask that it be voiced now so that the court is in a position to make that assertion. And they don't even need to voice it to us. They can voice it to the court outside our presence.
And who's your next witness?
Felicia Holmes,
All right, so it is Ms. Holmes? And,
not Ms. Hamilton.
Felicia Holmes, sorry.
and what do you anticipate Ms. Holmes say?
Judge, I believe she'll testify consistently with her previous statement that she gave in 2018. And I'm very familiar with the case law, and I would agree with counsel that the state cannot call a witness just for the purpose of impeachment. However, I'd also direct your Honor's attention to 9803 subsection 5, past recollection reported, in which a witness who no longer has a memory of an event, but has previously given a memorandum or record as to what happened, they may testify as in like a predicate as to that, and then that memorandum or record could be read into the record in support thereof.
So are you telling me that you believe that your witness is not going to remember what you said previously?
I believe there are instances in which her memory is no longer available, and that she would testify that she was truthful to law enforcement at the time of the statement in December of 2018, that she now no longer remembers because it has been so long, and that was a time when her memory was better, it was closer in time to the time of the offense. It was within 2 months of the offense occurring and the events of which she witnessed, so that would be admissible under 9803 of the code.
So you're telling me you've spoken with her, in a pre-trial discussion with her, and she said she has no memory of what she said at the trial?
There are parts of which she does not recall. That is correct.
May I retort? Okay. A couple of things. One, as with every other witness, the way that you prepare your witness is you refresh their recollection before you call them to the stand. So the notion that this witness is that all the state has been able to glean is that Ms. Holmes no longer recalls something which she said several years ago, and the state has not sought to refresh her recollection, in which case she would have been prepared to testify, then the pretext that she comes in here and says something different and then she impeaches her with a prior consistent statement, claiming that it's an effort to refresh her recollection, is disingenuous and in bad faith. And if that were able to be done, then this body of law would not exist. We also took her deposition, Ms. Holmes, on December 14th of 2022. No, that's not it. Okay, much more recent than that, no?
2010. Yeah.
December 2022, in which Ms. Holmes receded from the statements to which the state refers firmly and unequivocally. And the state is therefore, I think the language used in a lot of the cases that I have cited and in a lot of cases on the subject is the state needs to be surprised during the course of its examination at the contents of the statement in order to thereafter impeach their own witness. This notion that, oh yeah, well, she forgot, and while we talked to her, we learned that she forgot, and instead of refreshing her recollection, as we did with every other witness that we put forth prior to in preparation for her testimony, we're going to wait and do it on the stand by impeaching her with a prior inconsistent statement is it's a pretext, it's in bad faith, and it's improper. It's prejudicial, and it should not be permitted. Essentially, it amounts to hearsay because it's a prior inconsistent statement or a out-of-court statement that is going to be used to prove the truth of the matter asserted, which is different from impeachment, where it's not used to prove the matter asserted, it's just introduced to prove that you said something different at a different time. I think these cases are clear. And if that's what they intend to come and do, again, they're inviting error, and I'm alerting the court and the state to it before this miscarriage of justice ensues.
Thank you. Any other comment?
Just the record's clear in her deposition, counsel, she says, I don't remember or I can't remember approximately 26 times. The witness has been reviewing her statements and depositions for the past 2 days, and she still persists in saying she does not remember. So the NIE or 305 would be an appropriate remedy to enter the testimony from the prior statement.
By the way, Your Honor, I've highlighted those cases for ease of reference. Or at least 2 of them.
And what's her statement, counsel?
One is her statement.
All right.
This was previously provided to defense counsel.
I'll just give you a synopsis.
Yeah,
What is it that you want, or what you believe you're going to testify to, or if she doesn't remember, or what you are going to try to refresh her recollection with?
So she says that she was woken up at 4 a.m. Her daughter was screaming. The daughter was on FaceTime with Melly. Mr. Demmons then says he was saying that Mr. Demmons was saying that someone just shot the car up and was trying to shoot them. He then said there's like a car coming behind them and he's hiding. So then she asks Mr. Demmons, are you okay? His response was, I'm okay. She then asks him where are Stack and Juvie, the common nicknames of the 2 victims, and he said, I don't know if they're in the car, I think they're dead. So she then says, you think they're dead. She then goes through and describes her actions and conduct. She says that she called his mother, Jamie. Oh, I wouldn't go into the content of that conversation, because that would be hearsay. She then describes what she sees, which was her daughter on the phone on FaceTime with Mr. Demmons. She then says that she's going to come down, and then she describes her actions, that she hopped in the car and came down to South Florida. She said that at that point she asked and called Mr. Demmons again, spoke with him and said I'm at my friend Fredo's house. Fredo picked me up, so we went to Fredo's house. Then she describes that Fredo lives over in the same neighborhood that Melly lives in, and that she went in through another gate from the same neighborhood on that one. She then says shortly thereafter in her statement, when they get to Fredo's house, that Melly comes out and he takes Mariah and they go upstairs at Fredo's house. Then she also goes through and indicates that after this incident, that Mariah, her daughter, Mr. Demmons, Cortland Henry, and Cortland Henry's girlfriend are living together in a condo in Miami. She's going to testify that she didn't, and the statement also says that she didn't see any blood or anything on his clothes or anything like that. The question is asked then about her being FaceTimed, meaning Mariah Hamilton, the daughter of Felicia Holmes, FaceTimed, and her answer at that point was, he FaceTimed my daughter from the 772 number. So then she continues on, unless he got rid of that phone. He FaceTimed my daughter that morning at 4 in the morning, yeah. Then she's asked what's her daughter's number, and she gives her daughter's phone number at that time, 321-506-1313. Then it continues on, and so the law enforcement officer asks and says, I have his phone records, meaning that of Mr. Demmons, and he never called, there was never, then she identifies the phone number as, you have the 772-713-9807 number. She then continues on, he called and FaceTimed with, I talked to him on FaceTime. Then there's another incident, I don't know if potentially this could be possibly admissible, depending on the testimony. She says that they told me there were other guys in the studio, and he was saying that the other guys got mad, but they never said who was at the studio.
But you're telling me, counsel, if you spoke with the witness prior to, and the witness is not saying she didn't say X, Y, and Z, she's saying she doesn't remember.
Correct.
The incident.
In the presence of the witness and her attorney.
Thank you.
Your Honor, before I address the specifics there, I just want to put into the record some of the language that I think is most pertinent in the Curtis case, 876 Southern 2nd 113, which was a First District case in 2004. This is the language. It says, Florida allows litigants to impeach their own witnesses, but that does not necessarily resolve the constitutional problem identified in Chambers, which is another case that's referenced. Although a witness may be impeached in Florida by any party, including the party calling the witness pursuant to Section 90.608 Florida statute, it is still improper under Florida law for a party to call a witness merely as a device to place the impeaching testimony before the jury. That is Curtis. And the Florida Supreme Court of Dudley, the language that we're relying on, the case says one major issue requiring our consideration concerns the calling of Robert Bennett as a court witness and the presentation by the state of prior inconsistent statement as substantive evidence. There's language further down that says, in a similar situation, the First District Court of Appeals in Austin v. State 461 Southern 2nd 1380 Florida 1st District 1984 found that although a witness's hostility towards the parties may justify the trial court's exercise of discretion in calling the witness as a court witness, call a witness only to elicit prior unsworn statements for the purpose of proving the truth of the prior statement is error. District Court stated, under the circumstances of this case, it was impermissible to use the expedient of calling the witness as a court witness under Section 90.615 for the purpose of eliciting his prior inconsistent statement, either for impeachment purposes or as substantive evidence. To conclude otherwise would permit indirectly that which may not be done directly. Further language from that case says the fact that a witness may be hostile or unwilling does not mean that he is adverse. In order to be regarded as adverse under this section, the witness must give testimony prejudicial to the cause of the party calling it. So if you know that's what's coming in to begin with, there is no surprise. And then in the Felton v. State 120 Southern 3rd 126th 4th District 2013, the language that we're relying on says, in Ruff v. State 31 Southern 3rd 833 Florida 4th DCA 2010, this court explained, our Supreme Court recognized that consistent with federal precedent, a risk of abuse occurs when a prosecutor calls a witness who has previously given a statement implicating the defendant, but who has since repudiated that statement. In such cases, the purpose of calling the witness must be examined along with a balancing analysis under Federal Rule 403 to weigh the prejudice over the probative value of the evidence. Generally, however, if a party, and that's citing to Morton v. State 689, Southern 2nd, 259, Florida, 1997, that was receded from on other grounds. Generally, however, if a party knowingly calls a witness for the primary purpose of introducing a prior statement which otherwise would be inadmissible, impeachment should ordinarily be excluded. That is exactly what is taking place here. There's no failure of recollection. If the state, first of all, if somebody gets a call at 4 a.m. concerning a murder that occurred, you don't forget it. This notion that she forgot and she is now going to refresh her recollection by reading a statement into evidence that is impermissible, hearsay, is a pretext, and it is a 403 violation, and it is a violation of well-established law in this state that I've just articulated. And if the state was unable to refresh her recollection of such a significant event during preparation, the notion that she is now just going to read the statement into evidence on some pretext is a miscarriage of justice. If she has a witness, she has a witness. If she doesn't, and she knows she doesn't, calling the witness to impeach them by essentially introducing hearsay testimony is improper. The deposition that we took made clear that she she was receding from the statements that she made, and she gave explanations for why she made statements that she made. This is not a situation of failing recollection. This is a situation where they're trying to put in impermissible evidence under a pretext. And we object.
All right, anything else? Madam State?
No, Your Honor.
So we're going to bring the party in, we're going to see where it goes. All right, I understand what the objection is. God bless. I understand what the objection is. Let's see where it goes.
All right?
All right, let's bring the jury in.
Those are not the same statements that we're looking at.
Your Honor, I'm not sure we're ready for the jury. We're being handed totally different information that they plan to
Yeah, hold on.
put in through this witness.
Sir, what were you handed, counsel?
Counsel has been handed, was previously provided a first portion of the defendant's phone extraction. This particular summary, and there was a notice of intent to rely on summaries filed prior in this case by the state. This particular summary details the conversations between the defendant under the 772-713-9807 phone number, conversations with Mariah Hamilton, the witness's daughter, and her cell phone on that, as well as conversations with Miss Holmes herself, who is a party to some of the conversation. There was a group chat going on in which she is able to authenticate that the phone number, the 772-713-9807, which is reflected in those records, was being used by the defendant at times before, after, and during the homicide in question.
I take it these are just being introduced to identify the 9807 phone number
As well as
being a phone that Mr. Demons.
correct. So there are two first pages because on if you look at them there's a section in green, where he's telling Miss Hamilton this will be his third birthday he's been locked up on. I agree that that would be prejudicial to the defendant, so I created a version in which that specific item is taken from. So if you look at the green birthday and then just the first page and the second page, or if you look at the one another, with the exception of that alteration.
I'm not sure I understand. It sounds like you're saying these are conversations that took place while he was incarcerated.
No. He knew and was made aware he was going to be serving a sentence in Lee County, because that was a negotiated resolution. So instead of saying third birthday, I'm going to be locked up on WTF, instead I just put third birthday, and then her response on that.
To the extent that Ms. Holmes is not a party to the conversations, she can't authenticate. Now, I understand the state is saying that there are certain conversations which were a group conversation between Mr. Demons, Ms. Holmes, and Ms. Hamilton.
Correct.
Are all of those? Do all of the conversations in that exhibit fit that description?
No, she's also identifying her daughter's phone number in this other one.
Identifying her daughter's phone number, Your Honor, doesn't identify the participants of a conversation.
And so here are the other ones in which, for example, there is other participants in which her daughter's phone number is included with the defendant, the 9807 phone number, the manager's phone number, the little brother's phone number, the phone number of Miss Amy King is over there. Then there's the phone number down here as part of the third part, where it is the defendant's phone number, Miss Hamilton, and Miss Holmes, that are all listed on that.
And the state has not articulated a relevance of even establishing Ms. Holmes or Ms. Hamilton's phone number. For what purpose? I think I heard the state indicate a little while ago that there was no record, according to the detective, of this alleged phone call. So it's not as though they're going to say, see, here's a phone call between this number and that, because they don't have a record of it. So establishing the phone number, for what purpose? They might as well establish my phone number. What does it matter? If it can't be tied up, or it's not going to be tied up to some other record that they have. Saying that we want to put it in to show her phone number. Show her phone number for what? What does Ms. Hamilton's phone number have to do with anything? They can proffer it, but they have not yet articulated it. And there are several phone conversations there that do not involve the witness that they're about to call, and for those phone conversations to come in through that witness is just improper. How did she even lay the predicate to that?
Yes, ma'am, I don't know what you're trying to do.
So in terms of authenticating the phone numbers and laying the foundation for when these come in later on, I don't intend to publish these at this point. This is a predicate question that has to be established by this witness to show the phone numbers, the participants, the identity of those individuals, and some of the items in them.
When you say participants,
Correct.
does she know who the participants are? She's a party to this?
She is one of the parties. For example, one of the specific items that's talked about is the defendant killed a pet. It was a snake that died. She knows and knows who had that snake, the circumstances of how it was killed, so she can authenticate based on the content who was on the other side, who was using that phone. The point of contention is who had the 772-713-9807 phone number at the time of the homicide.
Okay, thank you. All right, so we're going to just see where it goes. You make whatever judgment you think is appropriate.
Okay.
Thank you. Sorry, something funny?
Pardon me?
Something funny?
Not that you're ruling. Your Honor, I mean no disrespect. And I hope you don't get that impression.
Let's bring the jury.
Thank you.
You're re-entering?
Ladies and gentlemen, thank you. Please be seated. Let the record reflect the evidence of the defendant. Defendant is Frank. This stage here to the jury. Ladies and gentlemen, I apologize for the delay. My fault. Everybody else, I apologize for that. In any event, I think we're ready to proceed. So, Madam State, you want to call your next witness, please?
State will call Felicia Holmes. And you're on this time the state was offered state triple J, previously found to defense. And you're 9803.6 in the business record. And a question.
Any additional objections, counsel?
No additional objections, but objecting not present.
Thank you. To be admitted.
Stage triple J will be marked stage 61. 61? 61. Thank you.
Counsel, will you come with us?
They were down the hall. With your permission, I send you a text message, Ryan?
Yes. Good morning. Are you Ms. Holmes?
Yes, I am.
Welcome.
Hello.
Come on up here. This is our witness stand. Ms. Holmes, when you get there, what I'd like you to do is remain standing. Raise your right hand if you sworn. Goes down. Thank you. Raise your right hand if you sworn.
Do you solemnly swear or affirm that one you should give the case of the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please state your full legal name for the record.
I'm Felicia Ashley Holmes,
Please spell your first and last name for the protocol.
FELICIA, HOLM.
Please have a seat. Ms. Holmes?
Yes, sir.
That microphone in front of you does not move back and forth. It'll just up and down, but not back and forth.
Okay.
You ready?
Yes, sir.
Counsel, you may proceed.
Thank you. Good morning, Ms. Holmes.
Good morning.
How are you today?
Not good.
Are you cold?
No, I'm just, you know, I don't feel comfortable.
Are you nervous?
I feel threatened.
So, Ms. Holmes, I want to start and just talk about who you are.
Yes.
Ms. Holmes, do you have any children?
Yes, I do.
Can you tell the ladies and gentlemen of the jury who is Mariah Hamilton?
My youngest daughter.
And how old is Mariah?
She's 22 right now.
And Mariah, did she have a romantic relationship with someone named Jamell Denons, also known as YNW Melly?
Yes, she did.
When was she involved in that romantic relationship with Melly?
I think it may be like 2016 or so till maybe 2019, 20.
Okay. Did you have the opportunity to meet Mr. Denons?
Yes, I did.
What did you refer to him as?
I call him Jamell Melly.
Do you see him here in the courtroom?
Yes, I do.
Where is he?
He's right here.
And what's he wearing?
A white turtleneck and a gray jacket.
Your made a record reflect and his court identification of the defendant.
Yes, record will reflect an in-court identification of the defendant.
So in October of 2018, had you met the defendant prior?
Yes, I did.
How many times had you met him in person prior to?
A couple.
A couple?
I think two maybe.
Okay. Did you follow him on social media?
I'm not sure. In 2018, I wasn't. No.
Okay. Did you know if he had social media at that time?
I didn't. No, I didn't.
Did you have a social media account at that time?
Yes, I did.
And what was your social media account?
I'm sorry?
What was your social media name
My name? For which one?
for Instagram?
Instagram, it's like Bling Queen 258.
Did you have a Snapchat?
I don't think so. If I did, I may have.
Oh. What about your daughter? Did she have an Instagram?
I'm pretty sure she did.
Okay. Did she have Snapchat?
I'm pretty sure she did.
So I'm going to show you what's been already admitted into evidence as 861. There's a couple of videos and things on that I would like to ask you to ask some questions about.
Your Honor, we'd object as to the predicate being laid for this witness to testify to any of this material.
Thank you. Yes, no.
So I'm showing you what is titled Memories 2018 October 9th 4:58 UTC, Melly, Montana. Can you see that picture there on your screen?
Yes, I can.
Okay. Who is the female over there?
That's my daughter.
And which daughter is that?
Mariah.
Okay. Who else is in that photograph with her?
That's Jamell.
I want to go here to this image. This is 2018, November 11th, 23:53:26 UTC. Again, Melly, Montana. Who is pictured in this photograph?
My daughter Mariah.
Do you recognize the individual in the back?
No.
Prior to coming into court yesterday, were you shown two photographs of the alleged victims in this case?
Yes, I was.
Were you able to identify them?
No, I was not.
In terms of your relationship with Anthony Williams and Chris Thomas, how many times did you met them?
Maybe Stack maybe twice. Judy maybe once.
And do you know them by their real names?
No, I don't.
How did you refer to them?
Stack and Judy.
Okay. So I want to go forward to some of the videos in this particular exhibit, specifically Memories 2018, October 18th, 2:17:49 UTC. Start with this one. I'm going to. So the image that is shown there, do you recognize the person in that driver's license?
It's blurry.
Okay. I'm going to show you another video, the next one. Whose driver's license is that?
That's my daughter.
The conversations and things that on there, do you recognize the voice?
I didn't really listen. I mean, you have to play it again.
The most important shit here.
Do you recognize the person who's speaking in that video?
Yes, I do.
Who is that?
That's Jamell.
Okay. So I want to go back to October 26th of 2018. Where were you living?
I was living in Cocoa.
And my geography is terrible, I think. How far away is Cocoa from Broward County?
About 3-4 hours.
What do you do for a living?
I'm a registered nurse.
Were you a registered nurse at that time as well?
Yes, I did.
Did you know the defendant's mother?
Yes, I did.
And who is she?
Jamie.
Have you met her prior to October 26th of 2018?
Yes, I have.
Have you communicated with her?
Yes, I did.
Did you have a phone number for her?
I'm pretty sure I probably did.
I'm not asking you to.
I don't know if I did or not. I can't remember.
Okay. So I want to go forward on October 26th of 2018 and talk about that early morning hours. Did you receive or hear a phone call or FaceTime video call in which the defendant was a participant?
I did overhear. I'm not quite sure exactly the context of the call, but I did overhear the phone call.
Okay. Tell the ladies and gentlemen of the jury what woke you up that morning.
Just hearing my daughter's voice.
Okay. What was what was the tone of her voice without saying what she said?
I don't remember. I don't know.
Okay. Do you remember anything the defendant said on that video?
Not verbatim, no, I don't.
Okay. Did you have an opportunity to read the statement you gave in 2008?
I read the statement,
Okay.
but
Was it
I don't recall, I don't remember anything from that statement, but I do remember my deposition from December 22.
So the deposition, that would have been 6 months ago?
Yes.
Oh. I want to go, and when you spoke, remember speaking with law enforcement in December of 2008?
I remember speaking with them, but I don't remember what they looked like, I don't remember their names, but I do remember talking to someone.
Okay, so Ms. Holmes, I want to ask you, were you honest and truthful with law enforcement when you spoke with them?
I would hope so. I mean, it was 2018, I went through a lot in that year, so I'm not sure where my mindset was at that time.
Did you lie to law enforcement?
I would hope not. I don't remember what I said back like 5 years ago.
Oh, of course. I understand it's been a long time. So in terms of the time frame, that was closer in time to the incident of October 26th of 2018?
If that's where you guys are saying it is.
You don't even remember?
I don't remember. Like I said, 2018 was a very hard year for me. My husband just went to prison. My father died. I had a lot going on, so I was really out of it.
Okay. And in terms of your conversations with the police officers that morning?
Yes. I do remember that they kind of bullied me and threatened my daughter and take her to jail for accessory after the fact. I do remember that.
Yes. And in terms of the statements that you made about what happened, you don't have any recollection of that? Did you read this statement multiple times?
I looked at it and I just didn't recall it, and no.
And so you indicated you hoped you were truthful with law enforcement?
Yes, I did.
I have to ask you to be more definitive. Were you truthful?
I don't remember what I said to them happening, so if I was to tell you something now, I could be lying. I don't want to lie on the stand because you're going to take me to jail. So I'm saying what you want me to say.
I do not want you to say anything. I want you to tell the truth.
Okay, that's what I'm doing.
Okay. So, Ms. Holmes, with regards to that day, did you lie to law enforcement?
I just asked an answer. Excuse me, overruled. Repeat your question.
I don't remember.
Excuse me.
Yes, sir.
Only one person can talk at a time, and there was an objection. I just wanted to.
Okay.
All right. You ask your question again.
Okay. So, Ms. Holmes, did you lie to law enforcement?
Not that I recall.
Oh.
I don't remember.
Okay. Going forward to the events of that day.
Yes.
When you heard that phone call, where were you?
I'm home.
Okay. Where was in home in Cocoa?
Cocoa.
Who else was there at your house?
My kids.
When you heard the phone call, did you hear what had allegedly happened?
I heard that there might have been a shooting.
Okay. Did you see any pictures or videos of anyone that was injured at that point?
No, I did not.
Did you see the defendant on the screen of that video call?
I saw his face, yes.
Okay. In terms of the method of communication, do you know if it was a FaceTime call?
I assume it was FaceTime. I couldn't say for sure what kind of call it was.
At the time of October of 2018 to December of 2018, did you know the defendant's phone number?
No, I don't.
Do you recall today what the defendant's phone number was?
No, I don't.
Okay. In terms of the information and stuff that you have regarding that phone number, was that saved in your phone at that time?
It may have been. I can't remember.
Do you remember what phone number you had?
No, I don't. No, I don't.
So, Ms. Holmes, to go back in terms of looking at your statement or any of the other things, refresh your recollection as to what the defendant's phone number was and what you had at that time.
I'm sorry, can you repeat the question?
Sure. You said you didn't remember the defendant's phone number.
No, I don't.
Would looking at a copy of your statement help refresh your memory as you want?
No, I don't think it will.
Okay. Would you like to try to do so?
Yeah, look at it for you.
Okay. And so, counsel, on the record, in terms of page 3 of each. And I'm going to ask you to just read this silently to yourself.
Okay.
And we're going to start here, this, and through here, okay? Silently to yourself. When you're doing that, does that refresh your recollection?
Yeah.
Your Honor, pursuant to 90.8035, the state would move at this time to read into the record the relevant portions.
Objection.
Can I speak, please?
Yes, sir.
And don't, it's 12 o'clock, let's take our lunch and recess. Don't discuss the case, don't film any opinion about the case, don't allow anyone to discuss the case because it's 30 no recess. All right, Steve, that head on here, sorry for the delay. What time? Let's say 1:30. Thank you.
Oh, sorry. Okay, thank you.
Thank you. Let the record reflect the jury stepped out. Counsel remain along with the defendant, assistant state attorneys, and our witness. Not want to step outside for a minute? Thank you. Just wait outside. So what are you anticipating this?
That her answer would start with, he FaceTimed my daughter from the 772 number. Question, yeah. Answer, unless he got rid of that phone. He FaceTimed my daughter that morning at 4 a.m. in the morning, yeah. Question, what's your daughter's number? Her number is 506-321-506-1313. But she may have another number because I changed her. She lost her cell phone and got another number. Her old number was, question, no, fuzz, answer. Her old number was 877-9609-321. Question, no. See, I have his phone records and you know, he never called it. There was never answer. You have the 772-713-9807? Question, 9807. Answer, I don't know whose phone that he called and FaceTimed with. I talked to him on FaceTime.
So, assuming that I let this portion in, is this going to be a reoccurring theme? That what else are you going to ask about?
In terms of that, as well as the initial part where she says she doesn't recall what he said verbatim. That would be the part where he's saying that someone just shot the car up and was trying to shoot them. So I asked him if he was okay, where he was, and he's like, there's cars coming behind him, like hiding. He was like, there's some, there's some, I think they're still out here or something. So I'm like, are you okay? He's like, I'm okay. I said, well, where are Zach and Juvie? And he said, I don't know if they're in the car. I think they're dead.
And that's the portion that you're looking to have admitted?
So far, based on her current state of her testimony up to this point.
Is there anything else?
If there's anything else that she doesn't remember on that, for example, the Frito Bang or Frederick Gibbons, is his actual name, aspects of that, anything about the condo in Miami, about the blood on the clothes. There's another part later on where she then describes the conversation again that he said. He just basically said that his friend they just got killed, and that he was like, there was lights coming, somebody's coming, someone's coming. I'm like, are they still out there, you know? Question, answer. It's like I don't know. And I said, we're on our way, just so you know, stay put, we'll come get you. So at this time, I'm thinking he's somewhere hiding in the bushes somewhere from whoever shot him.
And the statement goes on, there's other things that you're trying to get out through this witness that you're concerned she may or may not remember.
Those are the relevant portions, Your Honor. There's a lot of other things that she indicates in the statement that I would agree would not be relevant, and that wouldn't prove an essential fact that is at issue in this case. So I would not be seeking to insert the entire statement.
basically the portions that you just elicited.
Yes,
Correct.
and I can create, I have the ability to, in a Word document, to isolate those so that they can be succinctly read, provided to defense as well, so they have copies. But the case law is clear and the statute is clear. The state cannot introduce that statement, but defense would be able to evade the case.
Thank you. And your objection is?
Your Honor, we have a copy of her deposition, which makes clear.
Can I stop for a second? What is counsel reading from that? What are you reading from that?
I am reading from her statement of December 12th of 2018.
You're reading from a statement, not a deposition.
Correct.
Thank you. I'm sorry. Go ahead.
Thank you. And before I go any further, Your Honor, I meant no disrespect. And I appreciate your and understand your authority and your making decisions. Whatever reaction I had was not intended to convey disrespect, whether I agree with your decision. Her deposition of December 14, 2022 will clarify the issue of whether this is a failure of recollection that the state is trying to refresh, or whether or not this witness has recanted her statement and is making an entirely different statement about the facts of that night. In this deposition, she is not claiming not to recall. She said she wasn't certain about the time of the call, but she quickly got herself together and came down here, and it took about 3 to 4 hours, like she said, and she got here around 12 or 1 o'clock, which would place that call at 8 or 9 o'clock. There are several other substantive statements that indicate that she is recanting that statement she gave on that day. She says the reason that she gave the statement was because her daughter was threatened with arrest, like she said here. She said that she feels threatened, and the first thing she said there, she's not talking about Jamell, she's talking about the state. She's on an ankle bracelet. They arrested her in the Virgin Islands and brought her over here. And the statements she's making in her deposition do not support and I wouldn't say they contradict, but they're not the statements that are made in the statement that the state seeks to elicit. If the rules allowed her to put a witness on just to get in a prior statement, then they'd be in okay territory. The rules don't permit that. She's creating this pretext. Oh, you forgot that? Well, let me read it into the record. I would offer the court a copy of this deposition over lunch to review that makes it clear that she is recanting. She is not forgetting. She is recanting. And that's exactly what these cases speak to, and the process that the state is, what they're attempting to engage in is to violate and circumvent the rule and admit out-of-court statements to the truth of the matter asserted, which are hearsay, which are recognized to create constitutional problems, which have resulted in some of these cases in murder cases being reversed, murder convictions being reversed, and she's inviting error into this court, into this trial, and we'd ask the court to at least get a context of what is going on here, whether this is a failure of recollection, whether that's the way she's fashioning it, or whether or not what she said in her deposition does not comport with what she said in that statement that she's recanting, and whether the state is just using this rule as a pretext to get in statements that they're not having.
Thank you. You have the statement from Ms. Holmes as well?
I do, Your
That
Honor.
was taken on the road?
It was, yes, it's a sworn statement from Ms. Oath, from Ms. Holmes in December of 2018. And Your Honor, I would also add that some of the time frame and issues of that, those were actually clarified because defense provided the state with the typical discovery of Ms. Jamie King's phone records, which authenticate the statements, for example, that Felicia Holmes said she immediately called Jamie King. That is shown in Ms. King's phone records.
Who's Jamie King?
The defendant's mother. So there's outside sources that corroborate the sum and substance of her December 2018 statement.
All right, so I'm going to take a statement. If there's no objection, I'll take a statement and a deposition. I'll read those over lunch, and then I'll see everybody back here at 1:15. I told the jury to be back at 1:30. We'll resolve those issues, and we'll move forward. All right?
Thank you, Judge.
Thank you.
Clear that that is something the state can do under these circumstances. It's in the interest of justice rather than to have a witness who, for various reasons, is now professing a lack of memory to then be prohibited from introducing substantive evidence in the case.
So you're calling a witness that has testified that the witness doesn't recall, and you're suggesting that, I take it that she's feigning a lack of memory?
On some of them, I think it's accurate that she doesn't have a verbatim recollection of what was said. I think if she said that she did, that would be suspect. I think so. In terms of having a better memory back in 2018, 2 months after the incident or less than that, that is valid, and that she had said she was truthful with law enforcement at that time. The state has met the admissibility threshold on that particular issue.
Thank you. And what says the defense?
Your Honor, I think the state undercuts this argument by admitting what she perceives to be the case, which is that concerning the gravamen of what she's trying to introduce, she believes that the witness is feigning a lack of recollection. In other words, she is recanting. So this is not, and what's important to realize is this is not about determining whether we have a witness who is being honest or not. I think this rule contemplates a witness who may be being dishonest by recanting. And the issue is not whether or not the witness is being dishonest, and in the interest of justice, we want to put in what we believe to be a more honest statement. The question is whether or not you're putting up a witness to impeach them. Putting up a witness to introduce a statement previously made from which that witness has receded, or which that witness has recanted, which is what's going on here. And the rule is clear on that. Can't do it. It's hearsay. It should not be permitted. Any issue with respect to whether or not the statement is sworn or not, I think sworn statements typically contemplate an adversary having the ability to test credibility at the time it's made. Furthermore, this witness, when asked by the state, did you give an honest statement to law enforcement back in 2018? She's like, I don't know that I did. She posited the possibility that she could have been lying then, which further undercuts the indicia of reliability. She also said she felt threatened then because she was speaking, given that she was advised that her, and I think advised in bad faith, that her daughter might be charged as an accessory after the fact, when there was no evidence to suggest that. And she said she was acting then under threat, and that she's not certain whether she was being honest then. So for the state now to say, hey, she's having a failure of recollection, so we just want to read her prior statement into the record, is a pretext. And it runs in violation of the law in the state of Florida as explicitly outlined in the cases we cited and numerous other cases. So that's why we do this.
Thank you. So, counsel, I've looked at a couple of cases that came across. First is 880 Southern Second 561 Pierce Estate, Supreme Court of Florida. And second, 993 Southern Second 1108 4th PCA case, SL versus State. And in the first case, the Pierce case, that was an issue whereby during cross-examination of a state witness, defense counsel had asked whether or not the witness had previously told detectives and that he made a statement and expressed surprise at some piece of evidence, and the state, his response was he didn't recall, don't remember, anything along those lines, and the end result was that the Supreme Court said in order to resolve this claim, reading from the 8th page of the opinion, said in order to resolve this claim, you must examine the law relating to the admissibility of prior inconsistent statements. Prior inconsistent statements are not hearsay and can be admitted as substantive evidence. And quotes, if the declarant testifies at trial or hearing and is subject to cross-examination concerning the statement, and the statement is inconsistent with the declarant's testimony and was given under oath subject to the penalty of perjury at a trial, hearing, or other proceeding or in a deposition. Then it goes on and says this court has held that a statement given under oath during police investigation is not a statement given at an other proceeding and consequently is not admissible as substantive evidence. Second case I have is SL v. State, as I said, 993 Southern Second 1108. And that's a little more succinct. And at the second page of the opinion, it says, in order to resolve this appeal, we must determine whether the statement made by SL's mother to the deputy were admissible as substantive evidence. The Florida Rules of Evidence provide that prior inconsistent statements are admissible as substantive evidence if the declarant testifies at trial or hearing subject to cross-examination regarding the statement, and the statement is inconsistent with the declarant's testimony given under oath, subject to the penalty of perjury at a trial, hearing, or other proceeding or in a deposition. It goes on and says, interpreting this provision, the Florida Supreme Court recognized that a statement given during police investigation is not a statement given at an other proceeding, end quote. Doesn't appear to me that that statement is admissible as substantive evidence, counsel. So what the end result of all of this is, if you ask the witness eyes remembering the statement and you want to read it to him, I don't see how a curative instruction telling the jury it's only for impeachment purposes and not as substantive evidence is going to resolve it. So my goal would be just to keep it out, so I sustain the objection.
So just so it's clear, it is not a prior inconsistent statement. So the line of case law that you cited would not be applicable. It's a past recollection reported, which is a very specific subset. So my first Earhart on that specific issue, 9803 sub 5.
Excuse me one second. I left it on my desk. I'm sorry, Council, what section is it?
9803, yes, subsection 5, 9803.5, which in the 2022 edition starts on page 1104.
reference the Earhart citations. I provided a copy to defense and a copy for your honor. The light is located at 116 Southern 3rd, 270 Florida Supreme Court, 2013.
How about from the defense? Anything else?
Commentary on the case that was provided.
Yep.
Okay. The polite case, the very first headnote, says that the admission of the past recollection reported under exception to the hearsay rule requires the witness to indicate that the statement was made at the time when the events were fresh in her mind, his or her mind.
That's done.
And also attest to the accuracy of the memorandum of the opposite of that.
Excuse me, and that's in the bottom as well. You're reading the head note.
Yes.
I just highlighted the portion at the end. It says, we reject the 5th District's embrace of a totality of the circumstances test and affirm that in Florida, the admission of past recollection reported under section 98.803 subsection 5 requires that the witness indicate that the statement was made at the time when the events were fresh in his or her mind, and also attest to the accuracy of the memorandum or record. Then it goes on in conclusion. In this case, the proper foundation for admission of the witness statement past recollection reported was not established. As we've explained above, the hearsay statement was inadmissible because the witness did not vouch for its accuracy or correctness.
Absolutely, bro.
My thought is this, if what I heard her say previously was that she couldn't vouch for its accuracy or something to that effect, if that's what she continues with, I'm not going to allow you to admit the evidence. All right? So, are you ready to proceed?
Yeah.
All right, let's bring the jury. Are you ready as well? Yvette, you ready? Yeah. All right, bring the jury. Yep. Bring the witness in, bring the jury in. Grab the witness.
the sidebar brief.
Yep. Carry entering. Ladies and gentlemen, thank you. Please be seated. Let the record reflect the presence of the Devon, this council, this state attorney, ladies and gentlemen, attorney, or witness to Bishop Holmes remains on the stand. Ladies and gentlemen, I apologize for the delay. My fault. Names that I think we're already seeing now. Ms. Holmes, I just remind you, you're under oath. Thank you. Proceed, counsel.
Okay, so I'm going to talk a little bit about your deposition.
Yes.
Do you recall and you've been provided a copy of that deposition?
Yes, I got, my lawyer got provided.
When you, in that deposition, were you asked if your prior
Objection.
statement-
Improper impeachment.
I heard it over. You can ask your question, counsel.
Ms. Holmes, prior to that deposition starting, were you given your prior statement to review?
What you mean?
Were
I
you?
understand. The deposition that I did on December 22nd? Yes, it was given to my lawyer yesterday, right before, briefly to that, yes.
So the deposition you were at, that was
It was
provided
given
to
to my lawyer
your-
yesterday, yes, it was.
So, do you remember coming in for that deposition?
Yes, I do. I was in jail. You put me in jail.
Correct.
I remember.
And so it's clear in terms of you don't want to be here.
You're making me be here. Yes, I have a house with a band on my leg. I'm a nurse. I can't even work properly. Yes.
You were under house arrest because you failed to comply with this.
Objection.
No, you did not serve me for me.
Sustained. Listen, how we're going to do this is you ask your questions, counsel, and listen to her question, answer her question.
Yes, I
All right?
am. Yes, sir.
Thank you.
Okay. So going back to the deposition.
Yes.
On December 14th of 2022.
Yeah.
Do you remember coming to my office?
Yes, I do.
Do you remember being asked questions at that time?
Yes, I do.
Do you recall being given a copy of your prior statement of December 12th, 2018?
No, I don't remember that. I don't remember, but I'm pretty sure I do.
Okay, so what I'm going to do is permission to approach her on it
With what, counsel?
for deposition.
Objection, Your Honor.
I have to give her an opportunity to.
I saw my.
Excuse me. No question pending your view. All right, you can proceed, counsel.
Okay. So I'm showing her page 10, line 10 through 17. Okay, so just read them silently to yourself. Okay. So back on December 14th, 2022, where you asked if you need to make any corrections or deletions to the statement of December of 2018.
That's what the deposition said, usually.
And did you indicate that there was no corrections or deletions in the statements?
I don't remember, but that's what's on the deposition.
Okay. So, December of 2022, you said that this is the correct statement.
Objection. Sustained.
So, Ms. Holmes, is the December 2018 statement that you gave correct and honest?
Objection. Ask and answer.
Excuse me. I don't understand you're trying to answer the question before, but when they raise an objection, let me answer the objection first.
Okay.
Objection notice overruled. Question is the statement, what's your question?
Is this December 2018 statement correct and honest?
I don't remember the December 2018 statement.
In December of 2022,
Yes, ma'am.
did you state that it was an honest and correct statement?
That's what you put in the deposition. I don't remember saying it, so I can't remember verbatim what happened that day. I remember some parts of this deposition, but not all.
Okay, is there anything that you need to refresh your recollection to determine whether or not I'm being truthful and accurate as to what the question was in your answer?
I don't know to say that.
Oh.
Is that a question?
I asked if there's anything that
Please,
was...
one at a time. I just wanted to let her finish her answer before you ask the next question.
So, Ms. Holmes, is there anything that would help refresh your recollection?
I don't think so. I don't know.
Would the audio of the statement of December 2018 help?
Objection.
What's the objection?
It's irrelevant. She testified 3 times.
Excuse me. Thank you. Now as to this, go ahead, overrule.
I don't know. I don't.
So, Ms. Holmes, with regards to the events of October 26th, 2018,
Yes, ma'am.
did you travel down here to Birmingham?
Yes, I did.
Who did you come with?
My daughter, Mariah.
Okay, where did you go?
We went to one of Jamell's branch house.
And who helped with that?
Frida.
I know approachal has been previously shown to the defense counsel and marked as states N for identification purposes only. Ms. Holmes, do you recognize the 2 individuals in that photograph?
Yes, I do.
How do you recognize them?
I know Frida from being on Instagram from rapping. He's a rapper.
Okay, any other individual in that photograph?
My daughter's with me.
Okay.
I'm sorry, I apologize. I didn't hear that.
I'm sorry.
I didn't hear your answer. Could you
Which
repeat?
one? Do I recognize?
Thank you.
I do recognize Frida from Instagram for being a rapper, and I recognize Jamell who dated my daughter.
Here at this time, state the request and states N is the next number exhibit.
Any objection?
Relevant.
Overruled. It'll be admitted.
States N will be marked 862.
This is the photo that you can see on your screen that you just identified? Okay. So when you said Frito, is this the individual's house you went to?
Yeah.
Okay. Ms. Holmes, how much money has the defendant's manager given you since the October of 2018?
Objection. Relevance.
Watch from sidewalk.
For all of us, for him, his wife, and me to pay for it as far as he gave me $5,000 for Airbnb, and I gave him $1,000 to deposit that.
So he did give you.
Not for personal use.
Excuse me, can we clarify who he is, Jameson from his wife?
Objection, no, just clarify, counsel.
So it's clear, who is Jameson Francois?
He's Melly's manager.
And you mentioned his wife as well. Who's his wife?
I used to go by AA.
So AA and his wife.
We were all good friends.
So I'm looking now, previously shown to defense counsel and marked as stage triple M. It's a composite of 17 pages. Did you have an opportunity to review that prior to coming into court today?
Yes, I did.
Okay, and in terms of the individuals and the phone numbers that are on that, do you recognize your own phone number?
No, I did not.
Okay. Going forward through the contents of that particular item, do you recognize the conversation about a snake?
No, I did not. I know they had a sleep. I don't recognize this conversation.
Okay, with regards to the conversation about the snake that you do remember, what do you remember about the snake?
That they had a sleep.
What happened to it?
Objection. Relevance. Sustained.
Aaron, may we approach that? So Ms. Holmes, I want to ask you a question as to what was your daughter's phone number back in October of 2018?
I have no idea. I don't know.
Is there anything that would refresh your recollection as to what her phone number was?
No, 'cause I don't remember.
You don't even remember your own?
Yeah, no, I don't know.
In terms of, did you review your statement of December 18th of 20, I'm sorry, December 14th of, December 12th of 2018? Did you review that statement prior to testifying today?
Yes, I did.
And in that statement, were you asked, what is your daughter's phone number?
Objection.
I don't remember.
If I were to show you the statement, would that help refresh your recollection as to whether or not you were asked that question?
I don't think you would. But you can show it.
Your affirmation to approach?
Yes, ma'am.
Okay. 3 of 8. If you could just read silently to yourself. Okay. Looking at that, does that refresh your recollection as to what your daughter's phone number
I
was?
still don't recognize the number. It doesn't for me, but I don't know if that's her number. I don't recognize the number.
Okay, so you don't recognize the
I
number.
got 3 daughters, so I don't know.
Understood on that one. So, Judge Bennett, should you treat the witness as hostile?
Objection. Sidebar, please. Ladies and gentlemen, As the time of the attorneys, please, as you go to your room, do not discuss the case, don't form any opinion about the case, don't allow anyone to discuss the case in your presence and certainly no research. Please no further on your chair. Thank you. Let the record reflect the jury stepped out. Counsel remain while we defendant. Understand. Ms. Holmes, understand the counsel's side.
I was told to bring him in here.
Might be a good time to talk to him. So, you want to speak to your attorney? Any objection to that?
Yes.
What's
Yes,
your-
Your Honor. The witness is on the stand, and for the state to suggest to a witness who has already been sworn and is in the middle of testimony that she goes and talks to her lawyer, kind of intimidation, coercion, I think the rules have we do object to that. It's intimidation.
Well, let me ask you this. Is it something you think you need to talk to your lawyer about?
I'll talk to her. I don't think I need to, but I don't know what the problem is. I'm answering your question like she wants. I'm not sure what's going on.
Well, so my question to you is, do you want to talk to your lawyer?
Yes, I'll talk to her.
All right, so we're going to be in recess. You talk to your lawyer. And you go ahead, you can step outside, all right?
Okay.
And I'm going to continue with the argument here with the attorneys. So I guess the concern I had, you're asking me to declare her a hospital witness. So here's the mission is, I don't know if it was your position on it, she's asked, they'll allow her to ask these legal questions as she suggests in a sidebar. The problem with any of the questions, though, I don't want you to be asking specific questions, that things that she said previously she doesn't remember, and that you're just going to go ahead and put testimony before the jury. I mean, that's, it's not the attorney's questions that are in evidence. I mean, if she doesn't acknowledge it, or even after asking leading questions, she's basically saying, she doesn't know, or that's the end. You can't go much further than that. You can't put in evidence. Didn't you say X, Y, and Z? The police officer sees not acknowledge when she said it. I can't see, how you do that. You can't.
So, Your Honor, I think I can ask the questions because
What question?
in terms of, did you provide this phone number as the number for your daughter? Did you provide this number for the phone number regarding Mr. Dennis? Did you provide this information?
What information?
Whatever the particular statement may be that we're at that point in the questioning. For example, did you provide the phone and say that previously that you talked on FaceTime with the defendant? That you talked to him on the FaceTime on the 772-713-9807 phone number? So Judge, in terms of if I'm going to then impeach her with some other outside statement or some other prior consistent statement that she has made at some other proceeding, at that point, that's the concern as to her perjuring herself on that. So I think that's why it's important that she be allowed to speak to her attorney on that issue. And in terms of the prior statement on that, I still maintain that she has endorsed its authenticity and accuracy. Your Honor was provided with a copy of that deposition that the state referenced when we're talking about, and she indicated she was honest and truthful in that deposition, and she then endorsed the prior statement. So the prior statement should be allowed in on that, and if there's no concern as to any improper or anything on the jurors, because they would be instructed, as they always are, that no statements by the attorney are evidence.
Mr. York?
Yes, please. Your Honor, first of all, the state is now conflating issues. What we objected to and alerted the court to because we knew that this debacle was going to take place. I think it is evident that, yes, it appears as though the witness is not a major fan of the state. That's true. The state knew that going in. This is no surprise. These cases use the very language, surprise. In other words, what the state intended to do under a ruse at 803, 90.803 section 5 ruse is put on the witness to impeach that witness for that sole purpose of impeaching the witness, to introduce an out-of-court statement that is inadmissible because the state understood that she recanted. The state, under the pretext, oh, we don't know that she's hostile. We just think her recollection is failing. And we believe under 90.803 subsection 5, we can just read her statement. Unfortunately for the state, the Supreme Court has made it extremely clear that that witness has to vouch for the accuracy of the statement at the time it was made. And the Supreme Court also said in that context that in the context of an 803.5 exception, the contents of the record substitutes for the witness's testimony. This means that the reliability of the assertions rests upon the veracity of a witness who is present and testifying. The state is calling into question her veracity and calling her pretty much a liar, saying that she's feigning recollection and now attempting to essentially introduce a report of a police statement into evidence by the state testifying, asking the court to let the jury know that all this stuff that we're about to say, upon which we want to rest our case, is don't take it from me because I'm just a lawyer saying it, but then there's no point in saying it because there's no way to get it through this witness. She can't put her on to impeach, which is exactly what she's trying to do. The 803.5 is a ruse, and that's not working out, and now she's doubling back to the original, which is let me call her hostile so that I can lead, and instead of eliciting the testimony from her, I'm going to read it out of this report and say, didn't you say that? So what happens is we're going to now be in a situation where she's asking the state to tell the jury, hey, what the lawyers say is not evidence. So it doesn't matter that this witness is going to say, I do not remember that number that you just read to me. That you just let me see. I told you I don't remember it. So I now the state wants to come back to the podium and blurt that number out. She just said she doesn't recall it. So what's the point of saying it other than to introduce it into the record through the state attorney's lips? The rules don't allow her to do what she's trying to do.
Thank you.
So, Your Honor, in further support of treating a witness as a hostile witness, this has previously been provided to defense, but this is the Instagram production for Miss Felicia Holmes that I'm showing the court now that she has previously identified as her specific Instagram, and that it is saying the promises that were made to us by YNW for me to quit my job and they would take care of us were all lies. They didn't want us talking with prosecutors, but now they have all disappeared. I quit my job based on what Track and his wife or company said. Now look, we can't go home. We're spending all my money I worked for and they taking trips and enjoying life. If you think I was a beast before, wait until this trial. I'm not holding anything back. I'm doing what I should have done in the beginning. They can call me Miss Snitch Bitch. So, Judge, it's very clear from this record that my intention and what the witness has represented to me in all shapes and forms that she was going to be honest and truthful. So just say that it's improper for calling her just for the purposes of impeachment is incorrect. So to continue on in that same Instagram production, and this is in June of 2022, Felicia Holmes is saying, they made me quit. Told me that they would take care of us until trial was over. But guess what? Lies as usual. I was making $9,000 weekly. I didn't need shit from them, but everyone begging and pleading. Now they all ghost. I got something for track though. He lied to me and my child for the last time. Again, saying you're going to air him out to the prosecutor. So, Judge, in terms of the defense of the representation and counsel that is just being called for impeachment. It's also clear that this witness has received multiple benefits from the defendant based on her own statements there that she has endorsed that was her Instagram on that.
So, counsel, there's a couple things going on here. Number one is you indicated that it was the testimony was going to be admitted because it was in essence, forget the statute number.
9803 sub 5, it's a past recollection reported.
Past recollection recorded, and you gave me the polite case.
Yes.
And that indicates that you have to have a proper foundation, but it has to be not only there's a proper foundation, but it has to, the hearsay statement was inadmissible in that case because the witness didn't vouch for its accuracy or correctness, which is what we have here. The witness isn't vouching for the correctness or accuracy of the statement. So it doesn't meet that criteria. On the other issue about impeachment, this is not what she said. She said gave me a different answer. What I tried to read before was something from a couple of cases. And again, the synopsis of at the end of it, this is, I'm just reading again from the SL, a child case, the state 993 Southern 2nd 1108. It just says the Florida Rules of Evidence provide that prior inconsistent statements are admissible as substantive evidence if the declarant testifies at the trial or hearing subject to cross-examination regarding the statement, and the statement is inconsistent with the declarant's testimony given under oath, subject to the penalty of perjury at a trial, hearing, or other proceeding, or in a deposition. Goes on and says, interpreting this position, the Supreme Court of Florida recognized that a statement given during a police investigation is not a statement given at and other proceeding. So, then if you agree, I don't know where we're going with this, counsel, respectfully. It seems to me under either scenario, that statement doesn't connect. Now, I do have a message from Mr. Beres, B-E-R-E-S. He says he's his home attorney. He would like to speak to me. I don't know what he wants to talk with me about. To be candid, I'm doing his testimony. But anything he can say right here in open court. I don't have an issue with that.
That's fine. I really question the purpose in advising my client, Ms. Holmes, to consult me for a lawyer. I take it as an implicit threat to Ms. Holmes. We have an agreement that she comes in here today to testify. She's done that. She's honored her agreement. And, she's answered all the questions put to her. She may not be answering the questions to the satisfaction of the state, but she has fulfilled her agreement. And now Ms. Holmes is again placed in fear. And that's all I have to say.
Thank you. All right, let's, anybody need a restroom break or anything? You ready to go?
Yes, sir.
Pardon?
Judge, I think someone on the
I need to go do.
Sure. Take a short recess.
For this, the court to order this witness off stand. I think the state has demonstrated that the only purpose for which they want that witness there is for the improper purpose, and they're compounding the prejudice by having her remain there. I think that the state has something that's admissible that they can prop to this court. That witness needs testimony needs to be concluded.
Thank you. They will be heard.
The state's not.
Pardon?
There's additional information and things that's open to talk about.
Thank you. So this is my thought, counsel. I don't have a problem declaring the witness to be hostile to the state and allowing you to ask leading questions. I'm okay with that. I think that's been established. She's wearing an ankle monitor that was put on there by the state. I guess pursuant to this hearing where she was, you said she was hypnotized?
Yes, sir.
Regardless, so I will allow that. The problem I don't want to happen, so we're clear, is I don't want you to regurgitate things that are in her statement that she's not, that doesn't comply with either the two rules we've been going over. So I don't want you to be saying, well, didn't you say to, the police officer, Mr. Moretti, or whatever, the officer's name is Detective Moretti, that you saw them on FaceTime or whatever it was that they were on that date when the incident in question happened, and Mr. Demons told you X, Y, and Z. All right? The witness hasn't subscribed that the statement was accurate, so it's not getting in on her recorded recollection, and it's not getting into impeachment because it's a police investigation, not a deposition testimony or something along those lines. So it doesn't get in the way I read the rule under either of those two sections.
So
I don't want you to get in the back door, which you can't get in the front door.
No, just to make it clear, is Your Honor holding or stating that a police report cannot be used to impeach someone?
No,
Or,
I didn't say that. What I said was the statements in the police report, right? You can't just have that, read that back to her. Didn't you say this to the police officer? I don't want that to be done. I don't think that's appropriate. She says she doesn't remember the statement, doesn't know it's accurate. She didn't rely on its accuracy. And,
understood. And I just want to make sure it's also clear, under 9803 sub 5, the past recollection reported, there's no requirement in any of the case law or statute that the statement be sworn on that. If you look at that, because if there's other statements this witness has made that she may endorse as being truthful and accurate, and I'll have to ask her on that, then those are possibility of other ones that could be put in.
Your Honor, among the statements that we would like the court to forbid the state from asking in a leading fashion are the phone numbers or anything that she said to the officer on the day in question. What's the date that statement was made?
December 12th, 2018.
Nothing from that statement should be.
She'll ask you whatever question she thinks appropriate. You make your objections, but I don't think it's appropriate to be asking, didn't you say this, X, Y, and Z. I don't think that's appropriate because she's not subscribing that this is what she, that statement is truthful, so I don't want you just to be regurgitating the statement and asking her that. I don't want that done, and I don't want you to do, anyway, you'll see where it goes.
Yeah, just one thing, Your Honor, I'm sorry to belabor the point, but I want to make sure that the state doesn't confuse the court's ruling to be one of form over substance, and instead of saying, didn't you say this, say, isn't it true that, or anything where the contents of that report are uttered out of her mouth that she knows this witness had not adopted, and she's gonna get a no, and she's just putting it into the record. It's improper. And I've
Hopefully I
asked,
made myself clear, but that's why she's gonna be able to, counsel's gonna be able to ask whatever questions she deems appropriate. You make the appropriate objection if you think it's objectionable. I'm just gonna rule and go forward like that. I don't know what you intend to ask counsel. I just don't want it, the contents of that statement, regurgitating that in some form of leading questions, all right? I'll bring jury, let's get the witness back. Thank you.
Welcome. I'm sorry.
Jury entering.
Please be seated. Let everyone here reflect the presence for the jury. The counsel to get this. Ladies and gentlemen, the jury, all witnesses home for me to understand. Apologize for the delay. Counsel, please proceed.
Okay.
Please.
Okay, Ms. Holmes, when we left off, we were talking about a pet snake.
Yes,
Do you remember there being a pet snake?
I remember you talking to me about it yesterday.
Okay. And with regards to that snake, you recall it unfortunately passed away.
I'm pretty sure, probably, I'm not sure it's not here, I'm pretty sure.
Okay. Do you remember the name of that pet snake?
You know,
And in terms of the owners of that snake, do you remember who owned it?
I just know it was, I know the owner was it was in the house with Mariah lived.
Where did Mariah live at that time?
Should it be a more?
And do you know the address?
No, I don't.
Who did she live with?
Should have looked like Frankie, but you know.
Okay. Are you telling the ladies and gentlemen of this jury that you don't remember your phone number and
I'm
October
telling you that
2018?
I do not remember my phone number. I don't remember.
And are you telling the ladies and gentlemen of this jury that you don't remember your daughter's phone number?
No, I do not remember those phones.
And there's nothing that would refresh your memory or recollection whatsoever?
Objection, ask and answer.
Overruled.
That was 4 years ago. I've had so much trauma in my life since then.
Of course. So, is it fair to say that you were worried about Melly when you came down here to Fort Lauderdale on October 26, 2018?
Was I worried about him? Yes, I was.
You were worried about him because he had just been involved in a drug fight?
No, because they said his friend had been in trial.
Okay. And you were worried about him because he was hiding in some bushes?
Objection.
I don't remember him in bushes.
Okay. What do you remember?
I sustain the objection.
What do you remember?
I just remember him saying for us to come get him.
When you made contact with him later that same day at Frito's house,
Yeah.
is it fair to say he had no blood on him?
No, he didn't have any blood on him.
And is it fair to say that he left Frito's house and went up to a video shoot that afternoon evening?
Yes, he did.
Did you go to that video shoot?
No, I didn't.
Did Mariah live with Mr. Dennis after the homicide for a period of time?
Yes, she did.
Did she live in a condo in Miami with him?
Yes, she did.
Okay. attorney made other statements about the events of October 26th of 2018.
I don't remember making any other statements.
Do you recall a Instagram conversation with the co-defendant Cortland Henry?
I don't remember it.
Okay, if I may approach, I'll see if this refreshes your recollection as to that conversation. It's 3 pages.
Is there more, Counsel?
Not yet, Your Honor.
I don't remember it. I don't remember.
You don't have any recollection of that?
I don't remember.
Is that your Instagram, BlingQueen258?
Yes, it is.
Okay, and the conversation that you don't recall on that whatsoever?
Yeah, I don't remember it.
Okay. Is your testimony here today that you lied in those statements?
The line in my statements.
The allegations that you made to Mr. Henry?
I don't remember making those allegations, so I don't.
Do you remember sending screenshots of those allegations to a detective?
I remember sending a detective something stating that I didn't threaten Boardman.
No.
Because I remember that.
You remember sending screenshots of the conversation?
I remember telling him that I did, because he reached out to me and asked me that I threatened to kill Boardman. And I said, no, I did not threaten Boardman.
Oh.
I remember that.
Was there any threats made to you by the defendant?
No.
In terms of your daughter, Mariah, where is she?
I don't know.
After this incident, did she live with the family of the defendant?
She's always lived down there before this incident. She always lived there.
And your testimony to the ladies and gentlemen of the jury here today that you saw Jamell Demons on October 26th of 2018.
Yes,
That you spoke with him and heard him on the FaceTime conversation.
I did speak to him.
Oh. And it's your testimony that he indicated that it was some sort of shooting that occurred.
Yes, I did, yeah.
Okay, and it's your testimony that you saw him on your daughter's cell phone as a video call.
I saw him.
Is it your testimony today that after that you called Jane King?
Yes, I did call Jane.
And in terms of the conversation with Jane King, that occurred immediately after the FaceTime?
Not probably immediately, but sometime after. Not quite sure the time. I don't remember what time it was.
Oh. And it's your testimony to the ladies and gentlemen of the jury today that you were dishonest in your first statement?
I don't remember my first statement.
Okay. Is it your testimony to the ladies and gentlemen of the jury that you would lie?
I don't remember my first statement. I have no reason why you.
Yes or no? Did you lie to police?
I did not lie to you. No.
Yes or no? Did you lie to police?
I didn't lie to you. I don't remember my first statement. You're trying to make me say I remember my first statement. I did. For me to say no, I didn't lie with me. I remember my first statement. I don't remember it, so I don't remember.
Well, if you need more time to look it over, I have a copy of it.
I looked it over and I still don't remember it.
Oh, well,
I did it over 100 times. I don't remember.
Well, if you'd be so kind as to do it one more time. Just to make sure you can say that to this jury that this is not truthful.
Yes.
Please.
Objection asked and answered 5 times.
Thank you, objection noted. Move.
I honest to God do not remember any of this on here. Like, I don't remember talking. I don't remember. I had a hard time that year, so it's a lot that I don't remember about that year.
Is it your practice to let anyone first?
Objection.
Excuse me, guys.
I'm very cool.
Quiet, please.
You're saying is that
Sustained.
I don't know.
Excuse me, sustained objection.
Okay, so going back to the relationship with your daughter and defendant.
Yes.
How long did that last?
3 years. Not quite sure how.
Okay. During the course of that relationship, did she have multiple photographs of him?
I'm pretty sure she did.
Videos?
I'm pretty sure she did.
After this incident, on October 26, 2018, at Frida's house, is it your testimony that your daughter went upstairs with Mr. Dennings?
She did. They did go upstairs.
And went upstairs. And do you know about what time you got to Broward Town?
I probably got to Broward, maybe, I can't really remember the time, maybe, I don't know, but 1 o'clock was after lunch, because we went to right after. So it was after lunchtime. It was 1 o'clock.
Do you remember going to lunch?
Yes.
Do you remember where you went to lunch?
I don't remember which restaurant.
Do you remember who you went with?
My daughter and AA.
And that's James Francois' wife?
Yes.
And do you remember, your testimony is right, that you remember the defendant, how he was dressed without blood on his clothing?
I don't remember exactly what he had on, but I just remember that if there was no blood, because I would have been freaking out. So I know he had blood on.
No blood on him. Is it your testimony to this jury in terms of that you went to Frito Bang or Frederick Gibbons' house?
Yes.
Okay. Is it your testimony to the jury that there were other individuals present at that house? Who was it?
I don't know.
Do you recognize any of the individuals?
No, I don't.
Okay. Your daughter, she was present?
Yes, she did.
And in terms of your appearance here today,
yes.
You don't want to be here.
You made on here.
I did.
Yes, you
So,
did.
and in terms of you were served with a subpoena?
Never served.
And so you were ordered by the court to show up?
You never served me originally. That was a lie.
And in terms of your job?
Yes.
Did you quit your job?
I got fired because you put me in jail.
And prior to that,
yes.
Before you were put in jail, did you quit your job?
No.
Okay. So you never quit your job?
I had to leave because you told my lawyer to put a warrant out for me. So I had to leave my job.
Okay. So you left your job?
Yes.
Did the defendant ever offer to pay for you and your daughter?
No. I did my whole minute.
Have you ever made things contrary to that?
I don't remember.
If I may approach her?
Your objection.
Sure.
Can we approach? Sure.
You done with that?
Okay. Ms. Holmes, were you ever told the defense, or the defendant rather, would take care of you and pay for your bills?
Yeah.
Have you ever made a statement that is different than that?
Never said anything like that.
If I may approach her?
Sure. Just read this. I don't remember that. Okay.
So, Ms. Holmes, is it your statement testimony that you never stated the promises that were made to us by YNW for me to quit my job and they would take care of us for all lives? They didn't want us talking with prosecutors, but now they've all disappeared. That you've never said that before.
I don't remember anything.
Objection, Your Honor. Move, Ms. Rowe.
Thank you. Watch go sidewalk.
Ms. Holmes, did you ever say the defendant made you quit your job?
I know who was getting it. I never made you put my job.
Objection.
What do you mean?
If I may approach her? I'm sure this Next. So, Ms. Holman, I'll ask you again, have you ever made a statement that the defendant made you quit your job, that they would take care of us until the trial was over?
I didn't say anything like that.
Okay. So you're denying making that statement?
I don't say it.
Oh.
Objection.
Your Honor, can I just have a standing objection so we don't keep interrupting?
Now, any statements be heard on the standing objection?
Whatever defense is.
That's fine. Go ahead.
Okay. So, Ms. Holmes, in terms of made a statement to the effect of you were told to quit your job and the defense would take care of us.
Of the judge? No.
Excuse me.
The defense? No.
How much comes up?
And we have another one.
That was an inappropriate, improper question, and the way it's phrased was totally improper, and therefore I sustain the objection. I am instructing you that you will disregard the question. All right? I'm going to ask counsel to rephrase the question. Go ahead.
So it's clear. Ms. Holmes, did the defendant ever make you a promise to quit your job and that they had us?
Judge, asked and answered.
Thank you. Overruled. Proceed.
I don't remember anything like that.
That means that you've never said that.
I don't remember.
Excuse me, counsel. She answered the question. All right? Let's move on.
So with regard to your statement with Portland Henry, do you remember speaking and talking about your daughter with Portland Henry?
You know, I don't remember that. I don't remember.
When was that? Here, I'll give it to you again. This was February 5th of 2021. Do you still have it?
No, I don't remember that.
You don't remember that?
Yeah.
Did you talk to Portland Henry about your daughter's involvement in this case?
Nothing I can recall.
Ms. Holmes, did your daughter tell you what happened in this case?
Objection.
What's the objection?
Calls for hearsay. It's immaterial.
Not what the statement said. Did she say something about the case? Overruled. Not
she
what
never
was
told me
said.
about it.
Just,
She
did
never
you have
told
a
me.
excuse me. Not what was said. Was there a conversation?
Was there a conversation that your daughter told you what happened in this case?
What do you mean what happened?
Did your daughter ever
She never told me. She hasn't. I asked my daughter, did she know anything about this case? And she said no.
Have you ever made a statement different than that?
Not that I can recall. No, I don't remember saying anything like that. No.
May I approach her?
Yes, ma'am.
We object.
Why don't you show it to counsel first?
Can we approach?
Yes.
So,
I'd like to put the defendant, this counsel, is married. The jury's not here. They're adjourned. We all ready to proceed?
Yes.
All right. See if they're here, please. See if they're ready. Gary entering. Thank you. Let the record reflect the presence of the defendant, his counsel, the anticipated attorneys, the ladies and gentlemen of the jury, or witness remains on the stand. Please be seated. I need this home to go on the road. Counsel, please continue.
Let me mention something, ask you, did your daughter tell you, did you have a conversation with your daughter about what happened on October 26th, 2019?
Where's my actual issue?
Did she tell you what happened? Without,
No, she didn't disclose it, no.
have you ever made a statement that is different than that?
Your Honor, we'd object to lack of foundation, calls for hearsay, speculation, unless they can establish that that witness was present.
Thank you. Objection noted. As what I previously ruled on sidewalk. Proceed to your program.
Trust me, your messages from Instagram from February 5th, 2021.
Who was that Instagram? Is that the one that Instagram stands with Portland? I don't remember that Instagram.
Look at it.
I already looked at it. You're going to show it to me.
So is it?
I don't remember that. You showed it to me like 3 times already.
So you don't recall making
I don't recall making my statement.
Excuse me, one at a time. Ladies, let her finish her answer before you ask the next question.
So you don't recall making that statement?
No, I don't.
Okay. So you don't recall saying,
Objection.
Sustained.
so, Ms. Holmes, in terms, you said that your daughter didn't tell you.
Objection. Asked and answered.
Sustained.
So did you ever make a statement different than that?
Objection. Asked and answered.
Sustained.
Into the statements that with regard to October 26th of 2018. Is it your testimony to the jury that you remember coming to Fort Lauderdale?
Objection, asked and answered.
Sustained. Listen, I just want one of you to make an objection. Whoever's going to handle it.
Yes,
All
sir.
right?
I apologize.
Ms. Holmes, is it your testimony you don't remember why you came down?
I told you why I came down.
Okay, why is that?
Objection. Asked and answered.
Sustained.
Okay. Ms. Holmes, have you ever let me rephrase. Ms. Holmes, did your daughter ever threaten to cooperate with law enforcement?
Objection.
Sustained.
Ms. Holmes, did you threaten to cooperate with law enforcement?
Objection. Asked and answered.
Different question.
Why don't you come sidewalk? Why don't you do this question, please?
Ms. Holmes, have you ever made any statements about what happened on October 26th of 2018?
Objection. Asked and answered.
I don't know what statement you're talking about. Rephrase your question to be specific.
Ms. Holmes, did you ever make any statements specific to what was happening in the car on October 26th of 2018 prior to the homicide?
Objection.
Thank you. I still, come on side, please.
So, Ms. Holmes, I want to ask, were you present when your daughter spoke with law enforcement?
She was 17 and had been good.
Do you recall about when that happened?
If she was 17, that happened in 2018.
Okay. Without getting into what she said on that. Do you remember where that statement was taken?
No.
When you came down to Fort Lauderdale, was your daughter concerned for Mr. Dennis?
Objection. Calls for conclusion on part of this witness.
Based on your daughter's demeanor, how was she acting?
Sustained.
When you arrived in Fort Lauderdale and saw Mr. Dennis, you asked him what happened.
Objection. Asked and answered.
Overruled.
Sorry, repeat the question?
When you arrived in Fort Lauderdale, did you ask Mr. Dennis what had happened?
No, I did not.
Nothing further.
I have one question.
Yes, sir.
You came here and one of your first, you get it.
Objection, Your Honor, improper.
I haven't asked you.
Excuse me, Counsel, you direct your comments to.
I'm sorry, I haven't asked anything yet.
Ask your question.
When you first took the stand, you said, I feel threatened.
Yes, sir, I did.
Who do you feel threatened by?
Objection, Your Honor.
Overruled.
Christine Bradley, the prosecutor's office.
This prosecutor.
Yes, I did.
Thank you.
Anything else in this witness?
Yes, Your Honor. Ms. Holmes?
Yeah.
You said you feel threatened by
Of
me.
course.
Okay. Did you fail to appear for numerous court appearances?
No, I never served you, lied.
Okay.
Lied to the court.
And with regards to, did you work in Redding, California?
Yes, I did.
Okay. I'm curious. And so that was a location you were at?
That's why I was traveling as my kid.
Okay. And in terms of the prosecution, you have been served on various occasions to testify.
You served me a subpoena on November to be the next weekend. I was in California, 10 hours away. It wasn't even served correctly.
And prior to that, you were served with a subpoena in
Never.
February of 2019.
You never served me. I know you served at the location. I didn't live that anymore.
Do you recall coming to the courthouse in February of 2019?
Objection beyond the scope.
Your name of the courthouse.
Excuse me, come side, Markston.
So, Ms. Holmes, you even went so far as to hire an attorney
Yes,
to try not to show up.
I sure did.
And has the state offered you any money?
The state basically has me on a monitor. I have to go to my job with this. It's embarrassing. People think I'm a criminal. The state has run my life.
And in terms of your feelings and ill will towards the state and myself.
I just feel like you lock up innocent people.
And does that influence your testimony today?
It's not influencing my testimony.
Have you-
I'm telling you,
Have you, that's not,
I know.
Excuse me, hold on. Only one of you can talk at a time. You ask the question, counsel, you answer it, and when you let her finish her question, and then when she starts answering the question, you let the witness answer her question, all right?
yes, Your Honor. So that my question was non-responsive on that one.
Ask your question.
So, Ms. Holmes, in terms of the court order that was issued, you're aware that that was found to be valid?
No, I'm not aware of that at all.
Okay. You hired an attorney to go and represent you at the Fourth District Court of Appeals?
He had to hire an attorney because he tried to get him this far.
And that's false statements.
Objection. Excuse me. Counsel, you're not testifying.
I
all right?
agree on
Excuse me, you asked a question, all right? That's it, you asked a question.
And so the claims with regards to that, you hired an attorney?
Yes.
And you then tried to get any sort of court order requiring you to be here in court thrown out?
No, what I did was I hired an attorney because you were saying you served me this subpoena that you never served.
And that was found to be valid?
You never served me a subpoena that was never, you never served me.
Oh.
I've never seen a subpoena from you use address that you said you served. It was not my address.
Your testimony is that you have never been served to appear in court.
Sustained. Excuse me, sustained.
And so, with regards to your feeling threatened on that, have I ever any sort of physical violence against you? Or do you have any written threats from me?
You've intimidated me this whole time.
And
now.
And in terms of your participation in this case,
yes.
You understand that you were served a subpoena to appear here today?
You served the subpoena after you arrested me.
And
served the subpoena at the jail when I was in Broward County.
And you understand you're here pursuant to that court order?
I'm here.
And that requires, under the law, to comply with court orders to, and that compels attendance of witnesses.
I've been complying.
Nothing further.
Anything further?
No, sir.
Thank you. This witness excused?
Yes, Your Honor.
Thank you, ma'am. You may step down, you're excused. Want to please sign for her, please?
Sure.
Hey, John, I was just checking with counsel. That's all the evidence we have for today. So my thought is to remember the admonition. We'll see you back on Monday, though, 9 o'clock. Remember, do not discuss the case.
Tuesday.
That's right. Monday's a holiday. Thank you. So Tuesday, don't discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in your presence during no research. All right. Same admonition we give you every time we break. We're counting on you to follow it. All right, just leave your notepads on your chair. We'll see you back on Tuesday, 9 a.m. Thank you. What's it?
I don't know.
Let the record reflect the jury stepped out. Counsel remained along with the defendant and the assistant state attorney. Ms. Bradley, my clerk is advising me, I don't know if it was, I don't think there's any evidence that she had something that might have been marked as an exhibit.
It was not marked on it, it was just a copy of the transcript.
You're okay with it?
Yes, I have a good copy.
In any event, so jury's been excused, counsel remain along with the defense, so you have a couple motions from this time. You want to talk about those?
Yes, sir. As sure as I could predict that Tuesday after Monday, I made sure to stay up till 2 o'clock last night to get these cases, to alert the court to what was the state's obvious intention to put a witness on there for the purpose of introducing out-of-court statements that are otherwise inadmissible, instead of at least admitting that that was what the state intended to do, advanced a ruse, pretext that they were seeking to do so under 8035. It turns out that 8035, given the witness's testimony, could not be employed. And so the state then went back to Plan 1, the original one all along, of the state reading evidence from written documents and out-of-court statements, including police reports, statements on Instagram, arguments being had, into the record. Through the state's own mouth, knowing very well that it was improper, that the court had ruled that it should not and could not be done, and it does not somehow become relevant because they declare hostility, which they knew about from the inception. The state made a representation to this court that it was a complete surprise. That's not a credible statement. I think it is incumbent upon this court to discern the veracity of that contention. There was a witness there, happened to be Ms. Holmes' lawyer. He's present. The state is essentially trying to circumvent the rules, circumvent the order of this court, and testify to this jury about documents and information that it wanted to put before the jury, which it found no permissible way to do. The court warned the state, I don't want you trying to go through the back door, but you can't get through the front door, and they launched immediately into that pursuit. The jury sat there while the state made implication after implication, introduced admissible evidence after admissible evidence to the substantial prejudice of this defendant. And so not only did they do it after we raised the issue, they did it after the court ruled against the state and admonished the state not to do just that. And they launched into that pursuit. Mr. Dennis has been prejudiced. This jury sat there and watched this fiasco unfold with at least 10, maybe 15 sidebars after every 2 questions, with the implications that were being all predicated on the implications and the inadmissible testimony that Ms. Bradley herself read into and spoke into the record. And for that reason, we think that it was deliberate, it is highly prejudicial, this jury has been tainted, and we move for a mistrial. Oh, there's one more thing. If you don't mind, I'll have Mr. Alistine articulate what that might be.
This is your motion for mistrial, Mr. Addison?
Yes, it's our motion for mistrial.
There's a second one. All right, go ahead.
Yes, second one. Judge, in my entire career, I've never heard the state imply with no evidence whatsoever that the defense team would take care of this witness. And even though the court gave that instruction and told them to ignore it, that question, the defense team would take care of you if you answered like this, is so improper. Not only does it taint our client on the other questions, but it taints everybody at this table. And despite the judge, Your Honor's instruction to ignore it, it's pretty hard to ignore something like that. When their entire questioning for the last 30, 40 minutes have been so improper, and the court told them not to do it. And they proceeded and proceeded and proceeded. We're moving for a mistrial.
And just for the record, Your Honor, I personally have seen Ms. Holmes in the flesh or spoken to her twice ever at that deposition and today. Never by phone, never by text. Couldn't distinguish her from a can of paint until she showed up for the depot, and I haven't spoken to her since. So just to let the court know, there is no factual predicate for the implication, or not implication, the accusation made by the state that the defense sought to take care of her.
Same for me. I met her at the depot and saw her today.
For the record, it was my first time ever seeing her in my life.
Thank you. Well done, guys. Counsel?
Yes.
Yes, madam?
Judge, with regards to that, the statements that were in the record are what was used as impeachment, where it says they said that they were going to take care of us. Defense read into it and implied it meant it was never said the defense team in any way, shape, or form. So defense implied or read into that some additional context that was not intended in any way, shape, or form. I was basing it based in the records and the statements that this witness made and put forth in her Instagram account about this case on that. And in terms of the forming the questions, Your Honor, it was understood that I was put under very strict and difficult conditions to formulate any question, because defense obviously wants to limit, because they know the contents of what this individual has said and all of the statements that she has made that are damaging to their client. Hence why the state would be seeking to use her as a witness.
That means nothing, Your Honor. The fact that it's damaging, I'll concede that. It's inadmissible. And the statements of this impression that there is a catch-all, we're only trying to seek justice and do good exception to all the rules of evidence. And there is no such thing. If it's admissible, admit it through an admissible procedure. You don't try and end around the court's order and the case law by coming in on some pretext and doing exactly what I told the court would happen and create an entire prejudicial fiasco and introduce inadmissible evidence into the record. That's what occurred, and this jury has been irreparably prejudiced. Or that Mr. Demon's interests have been irreparably prejudiced before this jury.
Thank you. In any event, I'm going to defer ruling, take it under advisement. We'll see everybody back on Tuesday. I suggest that you talk with your client, discuss with Mr. Demons whether or not his feelings about the motion for mistrial. It's appropriate that he be consulted as well. But I haven't reached any conclusion about it, and so I'm going to see exactly what was said. I thought I heard what was said, and I'll check with the court reporter, get a little piece of that transcript, and we'll go from there. And I'll take it under advisement. But you talk to your client about it. We'll see everybody back on Tuesday.
Yes, sir. How many we hit, Judge? Since we're breaking early today, can we have a few minutes with our client?
Sure. I'd like you to take a few minutes with him. I'd like you to talk it over with him.
Yes, sir.
Can we have the cameras off?
I can't hear you.
The camera's off.
Oh, you want privacy? That's fine. The cameras can be excused. They can go out of the courtroom.
Thank you.
Because everybody can go out of the courtroom. All right?
Thank you.
Adjourn. This is like a private conference area.
Thank you.